Good morning, everyone. Our time is fast spent and we should be starting in very few minutes. But before that, I'd like to make a little bit of roll call for the CLMs that are participating. So if I mention your team code, kindly put up your hand because we need to be sure that all the participating universities are here. Okay? CLM A, CLM B, CLM C, D, CLM D. Are you in the house? CLM D. Anyone from CLMD here? Okay. CLME, F, CLMF, G, H, I, J, CLMJ, K, L, M, and N. Where is CLMN? Guys, put up your hands like you're ready for the competition. CLMD. Are they in the house? Okay, seems like we are all here. So we are going to start our session. So I'm going to give us like 5 minutes to settle. So the judges have gone to get a cup of tea, and when they come back, I'm going to request those who want to take tea to go and take tea. I'm saying those who want because I know some of you are from having breakfast. You could be okay. But just in case, you're going to first get a cup of tea, but it's going to be a working tea. So you go out, get a cup of tea and a bite, come back to your table so that the session continues as you're taking your tea. Is that okay? Guys, is that give me some energy? You guys are making me feel like, please. So that's what we are going to do. So once they come back, we shall briefly stay. I'll signal you guys to go out and get a cup of tea. Please don't go and start conversing and catching up. Just get your tea and your bite and come back to your table. So once you come back, then we shall open the competition as you're taking tea. So that once you're done or once we are done with the welcome remarks, we do the debrief session and then we get into our breakaway rooms to start the sessions. Okay? You can catch up in the meantime. All mooters and all coordinators, please make sure you have a tag. You will need that tag for a lot of things for today and tomorrow. So make sure you have a tag. If you don't, kindly step back to the table behind and the team will give you your tag. And make sure you wear those tags at all times. They're not for keeping. They're for identifying you. So please make sure you wear them. Yeah, it's me again. So now we are going to start. Are we all comfortable? Have you had tea? Ready to start? Okay, so we are going to have a security briefing from the hotel. And once we are done, we are going to invite the deputy ED of SEHA to come and give their remarks.
Good morning. You're most welcome to Hotel Africana. My name is Tony. I'm the security manager at Hotel Africana. It's our policy. We give you a security brief, some guidance or tips when you are inside a conference hall. The first thing is our registration. It helps us get the right people we have invited here for this conference. Then secondly, where you are seated, we kindly request you to know somebody seated next to you, your immediate neighbor on that table. There are scenarios where people are in the same workshops, but things does not go well. So kindly know somebody seated next to you. Then we request you to take care of your equipment that you are using inside the conference hall, especially phones and laptops. Maybe the small handbags as well. You take care of them when you are inside a conference hall. For more detail regarding that, the small writing book the hotel provides on the first page has got details how you take care of your items when you are inside a conference hall. Still, when you're moving out for lunch, still the hotel requests you to take care of your items when you are moving out of the hall. Our washrooms here, you exit through that main door, take my left, there's a corridor there on the left, continue there. For the ladies, yours is next to the hose reel. Then for the gents, there's a corridor before reaching the hose reel. You are going to find your washrooms there. Hotel Africana has got 3 fire assembly points. Just in case of an emergency, our team can evacuate you to the nearest fire assembly point. That's the little we want to share with you this morning. Our motto is you come as a guest, you leave as a friend. Have an easy day with us. Thank you.
Thank you very much. I hope you've all taken notes. And without further ado, I'm going to invite Ms. Nachibu Kanur Musisi, the Deputy Executive Director of the Center for Health, Human Rights and Development, to make her remarks. No, you're very welcome.
Good morning, people. Good morning, people. Hey, why are you tensed? Please don't get tensed. We don't have an ambulance on site. Last year we had an incident of a student who, I think, collapsed. I want to assure you that this time around we didn't think about an ambulance, so just calm down. Okay? Just do what? It's just one day, and by tomorrow, things will be done. And if you get tensed now, it ideally means that you're going to go through this whole thing every time you appear before judges, because it's going to be your everyday thing. So do you want to be like that for the rest of your lives? Just calm down. It is going to be well, okay? So just calm down, just relax, just know that you're going to speak to people. Composition is important in the profession that you're taking on. The moment you show that you're tensed, you have lost it. But if you feel that you're comfortable, you're relaxed, you're ready, the things are in your head. That at this time, the teams that are reading, there's no addition that you're making. You're lying to yourself. Just reflect on what you read. I swear you're lying to yourself. Because what are you putting in your head now? You're disorganizing your brain. So just calm down. The moot will happen. Anyways, I really want to welcome you to the 12th Annual National Constitutional Law Moot Court Competition. This is the 12th that we are holding. And I really want to appreciate all the universities for always being able to apply, compete, and deliberate on the moot. The idea behind the moot, this year we make 15 years of existence. And the idea behind the Moot, at least I was part of the team that conceptualized the Moot, came from the angle that Uganda's constitution does not have the right to health. I am not stealing exams for you. From that perspective, we noted that there was no substantive provision on the right to health. We raised, and I'm sure we still are reading the right to health from other parts of the Constitution. At least it's not in Chapter 4. But I know that it's in the National Objective and Directive Principles of State Policy. I think Objective 14B and maybe 20. And I know that at that time, we also looked at the Constitution and noted that in all African countries at that time, when I say at that time, this is 15 years ago, in all East African countries, Uganda had one of the best provisions when it came to protection of women's rights. I know Kenya's constitution is a bit more progressive in terms of SRHR than Uganda, but our Article 33 is one of those best articles that we have in the country. So the key question that we had then was that which organizations bring students together to think about understanding Uganda's constitution. And we noticed that we didn't have, at that time PILAC was not there. I know PILAC does some of these things now, it wasn't there. And we thought that one way of capacitating university students was for us to bring them together to understand the constitution through a Moot. So this Moot is meant to help you understand your constitution. I'm sure you sat down and read chapter 4 from the start to the end. And I am sure you all know that if you don't speak about Article 20 in this Moot, you would not have passed, because what are you speaking about if you're not speaking about protection of rights? Right? So when you read from chapter 4 in the beginning to the end, you're not going to see a substantive provision that is giving the right to health. And this is one of the things that actually pushed us as we put SEHAD together. The question that we had at that time was that what would be the value add? Because people had done everything in the health sector, but the judiciary had not been engaged. I'm sure people will come here and speak about petition 16. Now, some of us live and breathe the petition. So that petition that we took to court moved us to saying, where are the lawyers? Who do we speak with in terms of health? At that time, there was only one case. I forgot the name of the case. But I know it's that case where the lady was meant to, that case where the lady delivered, and I think she delivered along the road, and the LCs got her and pulled her to say she had stolen a baby. I forget the name of the case. It was the only health case that we had in the country. But you also realized that towards the end, it almost abated because the council picked it up and took it on upon himself. So I'm sure the next steps that you're going to read beyond environment, because environment is part of health, are going to be SEHAD cases. And along the way, other institutions have come on board. But why other lawyers are coming up to do the litigations on health is because we set the precedent, but also because we have opted to nurture students through these Moots. People have picked interest in health through Moots. And I'm very certain every year we speak to students. I have only seen 2 faces that are familiar here. I think I've seen Jay. Jay, where are you? I've seen Jay, and I've also seen one, Shakira. I think Shakira is with us for her internship. Shakira, where are you? Shakira is supposed to be seated on the other table. Why are you there? Please declare a conflict and leave your team. You're not for that team now, you're for SEHAD. So Jay and Shakira, I'm pulling them out because one of the things that we do is that we said one way that we can do it again is to provide internship. Do we do the best orarist? Esther, I don't remember. Is it the best orarist? It's the best orarist that we give internship, I think, for 3 months at SEHAD to just see what we go through to put such Moots together. It is work to bring you together. So this Moot is a bit special. I understand we had 15 universities that applied, 1 dropped off, but I know that in the room, I don't know what CLM A, B, C, D, E means. I'm sure one person knows, but I know that we have Nkumba University. Pardon? Yeah. I know that we have Nkumba University, we have Uganda Pentecostal University, Fort Portal, we have Gulu University, we have Uganda Pentecostal University, Kampala, King Caesar University, Islamic University in Uganda, main campus in Mbale, Cavendish University, Makerere University, Metropolitan International University, Bishop Stewart University, International University of East Africa, Kampala International University, Islamic University in Uganda, Kampala campus, as well as Islamic University in Uganda, a female campus. So to bring all these universities together takes time. And I know that this particular year we have disorganized us all, given so many underlying factors that we cannot come here and explain. I'm certain the team had a totally different date for the Moot. And I disorganized the team by saying we'll hold the Moot today and tomorrow. And I knew that next week we'll be having the Uganda National Conference on Health, Human Rights and Development. But we wanted to engage you as you get back in universities, rather than when you're settled and ready to set off. So that we allow you for the rest of the time to be able to concentrate on your studies. But also, what wakes up a person from a holiday, other than getting from a holiday and reading? It puts you in the mood of reading. So part of that was that. But also the second one was because the environment has changed, and you'll notice that this year, many of the things that we have done for the universities, we have not done this year. Sorry, for the Moot. So we realize that we have tried to squeeze as much as possible with the available funds to be able to hold the Moot. So when you don't see the goodies your colleagues would take in the past years, don't come and say, for us we didn't get. Chances are high that you might not get those goodies, because just like any other country in the world, Uganda was equally impacted on the conversations around the Trump administration. So were we. But the Moot is one of those events that we love so much, so the commitment had to move. So we have squeezed to bring you here, but we might not have every single thing that we used to give other students. I'm sure by now people would have bags, some people would have shirts, others would have that. Having said that, and for you to be able to bring back to the community what we call corporate social responsibility, I'm sure SEHAD has I don't know where it is, Esther? Where is our clinic market? Somewhere behind. So for us to ask the students and our judges today to be able to give back to the community and SEHAD, we have a market somewhere. So the goodies we used to give for free, this time round, we have a set. You don't want to live here without a product from SEHAD. I'm sure we have bottles, we have pens, we have bags, we have key holders. I don't know how many other things, but I'm very certain at a costly price, a very cheap price, and you can give back to SEHAD on that regard. At the same time, in 2023, we have been faced with several things in the institution. We run a legal aid clinic. We receive so many cases of violence in the institution. And these cases are not funded. No donor funds, by the way, litigation. They don't, because litigation take forever and projects come for 2 years and go. In 2 years in Uganda, it's rare that you have a judgment in a case. It's very rare. So one of the things that we did was to innovate this. I'm not sure if I can hold it, but this is meant to support the child survivors of violence. This is what we call, I don't know if I can lift, I don't have a team here, but I want to be sure that people can see, it's empty. So what you do, thank you. What you do, because we receive so many cases of your relatives, of your friends, of your children violated, from as low as 3 months old to as high as 18 or 17 years of age, even rape. We have so many defilements that we run. I think in the legal aid clinic, we receive about 10 to 15 cases a quarter in 3 months across the country. That's why you'll see us in Kapchora, you'll see us in Kabale, you'll see us in Kasese, you'll see us in Namutumba, you'll see us in Iganga, you'll see us in Imbale. Some of the things that bring us there are these cases. So in 2023, we launched this legal aid fund to support the survivors of violence. One of those cases that we are taking on, for example, is a case of a girl who was defiled at the age of 10 by the father. That's during COVID. And the father defiled all the three. But this particular 10-year-old, who is now 15, got an issue with the backbone. You can see it. People will put money, never mind. I'll just say that if you don't have cash, there's a MomoPay number. You can just dial, and the person holding the MomoPay number is somewhere behind there. So she has the phone. She can help you go through. Bukira, where are you? Where? Hey, people want to see you so that when they're doing MomoPays, they see you. Oh, she has gone to the bank. Okay. So why we do this is to support. This girl was defiled by her own biological father during COVID. She was defiled when her three sisters were in the house, when her mother was in the house, severally. But this man was so clever that because they have one room, one bedroom, and one sitting room, he would get saucepans, basins, and place near the bed. So every time the wife had the children make noise, when she stepped down like this, she would step in the saucepan. The father would hear and would run out until one fateful night when she said enough is enough. As we speak, this girl has been struggling with her life. She's the reason we launched this, by the way. Has been struggling with her life because she has got to have the backbone treated. She can't stand the way I've stood. If she was here, she would be down by now. She can't stand firm. So she still has to get the medical education, but also she needs to go back to school. So what we have done is to take her back to school as an institution supported by staff, not the organization. And she's in senior 3, but she still takes her medication as we progress with her case. So that and so many others. We have ones where 3 months olds come and parents are just coming and saying, we need your support. The support is beyond litigation, because litigation will have the lawyers who will do. But the support also includes ensuring that that evidence that people need is actually protected. For someone to call and say, I have found a man on my child, the child is 5 months. The first questions of reserve evidence are things that we have to think about. But usually they don't even have 1,000 shillings to move to police and fill the forms. So that's why we bring this and carry on that engagement every time we speak. So as you sleep, think about that child that is struggling and needs legal support. So this moot is going to be presided over today by our magistrates from the various magistrate areas, but today they will act as our judges. And we have her worship, Ariot Esther, they're seated on the other table. We are humbled to have you. We have her worship, Nangobi Jackie. Thank you so much for making time. Her worship, Kambeda Lydia. Thank you so much. That team has been calling her senior. I'm sure she's leading the team today. His worship, Busura Ivan. Thank you for making time. His worship, Wegoye Joel. Thank you for being with us. Her worship, Wiwo Fatuma. Thank you for making time for us. And his worship, Mugweri Ambrose. Thank you so much for making time to be with us. So while we are referring to them as her worship, when you go there and say your worship, it is up to you, because I'm sure our problem is at the High Court level. I'm sure you have gone through these semantics, right? They will be sitting in and providing you guidance. One of the challenges that we have seen with you is that you get pissed. You really get pissed as students with the guidance the judges give you. But the judges are meant to guide you, to help you understand what we call court decorum. Okay? So please listen to them. Do not want to defend so much. Compose yourself, listen in, respond when they ask the questions, because they've been on it for years and they understand court decorum. Do not take the moot as just a competition for you to say we are the winners, when in terms of skill you've taken away nothing. I've told you that the intention of the moot was to actually skill you into constitutional understanding of the Constitution, but also how we manage a court. So this year, we designed a moot problem. I am 100% sure that even when we have Shakira at office, she did not see the moot problem. That even when Jay is part of us, he did not see it. Did you see it? We make sure there is no leakage. I don't think she will tell you that she didn't see it until when we say we are ready to release. So this year's Moot is meant to help us understand the dynamics around gender justice and the dynamics around litigating health. So you'll hear so much of this as you Moot. But also, we have an element of advocacy as we litigate, which we are sure will get you into that. And how you present yourself is quite important, because what you're going to do is not new. People have done this, and people continue to do. Some of you have gone through it. Others have been carriers of files of lawyers as they go to court. So you see what your seniors do. So what you're going to do is exactly that. I wish to ask you to kindly stay calm. Your health matters a lot. If you didn't take your pressure medicine in the morning, please take it. The roads are blocked. By the time we rush you to the hospital, we don't have an ambulance meanwhile today. By the time we rush you to hospital, it will be you as an individual, and the university will not even think about the fact that they brought you here. Right? So please, if you wish to take your pressure medication, step aside and take it. If you feel you're not composed enough, I know you've been pairing two, ask your colleague to take on the mantle. It is okay. Okay? The most important is that we can have a healthy Moot. I am saying this because last year we all looked and said, what do we do with the student? The student was sick, had pressure, did not take medicine, had run away from a drip. And I mean, why? Okay, so please calm down. We are here to support you when you need guidance. We have a whole team of about on. Just tap on anyone, even if it's me, and say, I feel like I want to run to the toilet, but I don't even see where it is. We shall take you. We are happy to support you through that. When you feel like you're not ready, please say. Okay? Do not shy away from us. We are here to work and engage with you. The judges are human beings. They also listen. They will give you that time. While we are timing you, please, when you need more time, do not stop the point along the way. Boldly stand up and say, can I seek for 1 more minute or 1 second to complete my presentation? They will listen. Okay? And lastly, your social network is what makes you. If you leave this room seated on a table with people you came with from Bali, from wherever you're coming from, the world is round. If you don't make friends today, you'll never make friends. Okay? So one of the things that you need to pick up is also to social network. Your social capital is quite important, because from school, the world will divide you. It will share you, and you'll never see people anywhere. When you exchange contacts today, you'll never regret the future. I wish you all the best in this Moot, and may the winner take it all. Thank you.
Thank you so much, Noor. So we are going to straight away head into our debrief session. Before I debrief, if you have a tag, if you're a mooter or a coordinator and you have a tag that has Moot clerk, please come and give it to me. When I come that side, please give it to me so that I can be able to give you your rightful tag. Yeah, so we are going to have a debrief, and as I'm debriefing us, maybe in the next 5-6 minutes, we are also going to be having a debrief for the judges and the clerks simultaneously. So I think for me, or for us from our end, is to thank you guys for participating. We don't take it for granted. We issued a call, you applied, and you are selected to participate. So thank you for participating. Thank you for being compliant, adhering to the instructions, Thank you for accepting the different changes that happened. You know that you were supposed to convene this moot originally, as had been communicated to you. We were supposed to do this moot in September, but somehow we had to push it due to factors beyond our control. And that is what caused one of the universities to drop off, because they were going to be engaged in examinations. But so thank you for accepting the different changes that we made and for cooperating with us, but also for submitting your documents to us. And speaking of submitting your memorials, after I'm done briefing here, we are going to invite one of the judges to give you feedback. Like we communicated to you, Seha does not mark those memorials. So whatever marks you're going to see are not marks that came from us. When we receive those memorials, we submit them to the judges. You see there are 7, and each of them marked those memorials. We share all the memorials with them as applicants and as respondents, and they mark. When they mark, they submit to us the marks. And when they give us the marks, that is now when we do the total average of the memorials of each team. So when you come back from the second preliminary rounds, you'll find the memorial marks there. Just know that we've put the average you got from the total average from every judge that marked, and then the average of 25%, because we communicated to you in the instructions that memorials contribute 25%. So please know, as you go to your different courtrooms, as you make your oral submissions, please remember that the oral submissions contribute 75%. We shall get your total average. Of course, they're going to grade you individually, but even as individuals, the two of you contribute to one average for the team. And that average for both the first and second preliminary rounds is going to be computed by someone there taking care of the tally center, who is not me, who is not Ruth. And they'll get for us the total that you get and compute to 75%, and we shall add your marks for memorials. That is how we are competing for the oral rounds. So to get who is proceeding to the quarterfinals, it is going to be by the team that has the highest marks. I'm emphasizing this so that when you go to those rooms to compete, please give it your best. Don't take it for granted. Okay? Yeah. So back to the oral rounds, we are going to give you, instructions remain the same, but just for emphasis, because sometimes the students forget this. And coordinators, please take note and guide the students. The time for the oral rounds is 1 hour. That 1 hour has 20 minutes for each team to make their submissions. If it is CLM A and CLM B before Judge C, CLM A has 20 minutes to make their case. You can decide as a team how you're going to divide your time. But just to caution you, please ensure that you keep to that time. Okay? Discuss what works for both of you, but make sure that whoever has been given 10 minutes keeps to the 10 minutes. Why? Because if you go over and above, you're affecting your second team member. And once you affect your second team member's time, you won't give them enough time to submit, which is going to affect your mark. So give chance to both parties to speak, agree on the time location amongst the two of you, and please take note of the clerks who are going to be by the judge's side. Those clerks are going to have time reminders. You can tell them before the session starts at what point you want them to remind you. You can tell them, for us, please remind us maybe at 5 minutes, or at 10 minutes. And please, once they remind you, take note, because we are also going to be strict about that time. It's unfair to give a team 20 minutes and another is using 30 minutes to make the same case. So we are trying to be fair here, and please, if you don't keep to the time, the clerk is going to report to us or the judge, and that is going to affect your team. So inform the clerks and tell them what time reminders work for you or are comfortable for you, and adhere to those. But so each team has 20 minutes to make their case, that's 40 minutes. And then we are going to have 5 minutes for each team for rejoinder, if any. If you have to rejoin, you can rejoin. It's also okay not to rejoin if you feel like everything has been said. But so each team is going to have 5 minutes, and then the judge is going to have 15 minutes to give you feedback. Are we clear as to that point? The judge will give you feedback. They'll communicate back to you. And also, speaking of the judges, even in their debrief, we inform them that when the session is done, they have an obligation to read back your marks to you. Please do not leave that room without knowing what you got as an individual and your team average. Okay? So they are going to read back to you your marks so that you leave the room knowing that Esther, I got maybe 70%, and my colleague got 20, and the total is 90. Get to know those marks for your own good. So about the grading, like I communicated, each person is going to be graded individually. But even with the individual's grading, the two of you as a team are going to get an average. So give it your best. Do not let your team member down. Don't say Esther is the one who is handling 70% of the case. It's a team effort. So try to give it your best, because whereas you're going to be graded individually, your total is going to contribute to the average of the team. And like I said, the oral rounds contribute 75%. So don't expect to come here and find your marks out of 100. Why? Because the 25% is for the memorials, and we're going to pin up those marks for you. And then, like I'd mentioned, the memorials were marked by the judges. But when we pin up the marks, we are going to focus on the average and the 25%. So if by any chance you want to know the details of what Judge A, Judge B, Judge C, or if you want to be sure that for me as CLMA, I want to know what Judge A, what Judge B, what Judge C gave me, feel free to come behind there to either me or Ruth, and we shall show you your marks. Because some people are only comfortable after they are sure. So in case you want to see the details of your marks from each judge, please come behind there. We shall show you your team's marks per judge, only for your team. But if you're not, if you don't mind not seeing them, that's also okay. But we shall pin the marks by average and by 25%. Yeah. So I'll just emphasize about the quarterfinals and the semifinal and the final rounds. So once we're done with the preliminary round, which are going to be graded by the highest scores, like I communicated, we are going to get the top 8 teams. There are 14 teams participating. So give it your best. That's quite a number. So out of the 14, we are going to get the top 8. The top 8 teams are going to proceed for quarterfinals. Again, for the preliminary rounds and the quarterfinals, you're proceeding before the High Court. That means you're appearing before a single judge. Okay? I emphasize this because sometimes people forget. Even in the memorials, we had communicated in the instructions and the problem statement that you're appearing before a judge, a single judge, raise your issues in the High Court. And we still had people raising issues or arguing their case or developing pleadings for Court of Appeal and Supreme Court. And then we're wondering, how are you going to the Supreme Court or Court of Appeal without even making your case before the High Court? So that's why we are emphasizing this. You are appearing before a justice or a judge of the High Court, a single judge. Take note of that. That's for the preliminaries and the quarterfinals. Quarterfinals is for the top 8 teams that go through the preliminary rounds. But now when you get to the quarterfinals, we start the knockout stage. You all know what knockout is, right? Team A versus Team B. If Team A knocks out Team B, Team A proceeds, Team B is knocked out, okay? So it's going to be by knockout for the top 8 teams. The top 4 teams that emerge victors from the quarterfinals are going to proceed to the semi-finals. So we are tweaking it up a little bit here. We got feedback. You know, we always get feedback from the students after the Moot and the judges. And part of the feedback we got was that last year, the teams that proceeded to the semi-final did not get time to conference or to argue on their issues. So the top 4 teams that proceed from quarterfinals to the semi-finals are going to be given time, limited time, really limited time. As soon as you get to know who you're going to argue out the case with, we are going to give you a few minutes to agree or to conference or to schedule. I know by now you know the problem statement, right? You don't need to read it again, but just know, prepare your minds mentally that once you go through from quarterfinals to semifinals, we are going to give the 4 teams, the two teams, to sit down and schedule briefly and agree on their issues that they're going to raise at the semifinal stage or the Court of Appeal stage. Then when we get to the semifinals, of course, you're now appearing before the appeals court or the Court of Appeal, and it is going to be a bench of 3 judges. Don't expect a single judge now. And you must make sure that you impress each of the judges. So, semi-final stage, we are going to a bench of 3 judges, and it is still by knockout. And then finally, the 2 teams that emerge victorious will definitely proceed for the final tomorrow. And after the semi-final round is done, those 2 teams will also be expected to sit and conference as well. Okay? So that said, being knocked out is not the end of the Moot competition. Please do not lose morale, and you feel like you're now out of the competition. You don't even want to come and support the others. You feel like, for me, the road is done for me. No. We encourage you to keep supportive. Some of you, when you're knocked out, no one wants to be knocked out, but it's a competition. Someone has to be knocked out. But some of you, when you're knocked out, you lose interest in the mood and you start doing your own things. Please and please, we are encouraging you for this year. Let it be different. Keep being part of the mood, because a lot more is coming for you. Don't leave the room empty. Do not go to your rooms to sleep, because after all, I'm out. Please stay here and listen to others. You never know a thing or two that you could pick. It's a competition, but you're also here to learn from each other. You could learn from Team A what maybe you did not do. So take it in a positive way and just keep being part of the competition. Coordinators, do not let the students be in such a state. And that's why you are there to guide them. We expect you to keep being part of the competition. Even tomorrow, don't do what happened last year where the judges arrive here and the room is empty. These are judges of the Supreme Court, Court of Appeal, and the High Court of Uganda. And even in actual practice, the judge doesn't wait for the courtesy of court. So please, even if you've been knocked out, even if you're not going for the final, it's not the end of the road or the end of the world. Keep part of the mood, and please show up here on time tomorrow to support the colleagues that you can support. That said, I think I want to invite His Worship, Busulwa Ivan, to give a little bit of feedback about the memorials. It's important for you to get feedback so that next time you're doing memorials, you know how to do better or you know what to maintain. And once he's done with that debrief, we are going to break into our courtrooms. We have put up a schedule behind there for the first preliminary round. Once you see your room, just go to your room. This is going to be the main hall, Katonga. If you're in Sezibwa, you're going to take the left and proceed. You'll see Sezibwa. If you're in either Tana or Niger or Zambezi, you'll take this side, the right, and we shall direct you. We shall be there to guide you where that hole is. And if you're in CP, you're going to go across the pool. So once we are done getting feedback from the judge about our memorials, that is when we are going to break our way into our halls and get ready for the competition. Get there, take your seats. The judge is going to find you, and the clerk. With that said, I wish you all the best, and may the best team win. Thank you.
Good morning. Morning. How are we? You're tensed up, I can see. It's okay, these two shall pass, right? It shall pass. Yes. So my role here is to give you feedback on your memorials. This is not only me speaking, it is the entire team. So if I say some bad things about your memorials, just know it is not me. It is one of those people. Me, I'm going to say good things. So, first off, I want to congratulate you for preparing reasonably good work. The reason why I'm congratulating you is because it was on short notice. And that notwithstanding, you came up with something good. At least you didn't give us things you yourself wouldn't understand. That said, there were some negatives, if I may. Most of you had a problem relating your facts to the pleadings. My colleagues told me that some of them saw strange things. The pleadings are different. Actually, there is only one team which had pleadings. Some of you went straight to the facts, issues, resolutions, etc., etc. The second issue, of course, now that can be summarized into failure to follow instructions, because you ought to have followed instructions as your first indicator of success in any assignment. On the question of issues, I think most of us struggled on raising issues. So that is an area I think we shall work on. Of course, not in the next Moot, but in practice. Now the issues, the arguments. Most of your arguments were not issue-based. They were academic. And among the issues we look at is persuasiveness. You can't persuade a judicial officer if you don't marry your submissions to the issues you've raised, and by extension to the facts presented. Some of you just cited provisions of the law and left them there. For those who attempted to do so, did not exactly interpret them as they should. So someone would, for example, cite an instrument, quote it verbatim, not paraphrase, and then move on to another thing, which was quite catastrophic. And of course, it is the danger of academic tones in submissions. So, whereas you did extensive research, you fell short to the case that was presented before you. To me, as a judicial officer, I would be quite happy with a lawyer who knows the facts in and out than one who does not know the facts but knows the law. You can't know the law when you don't know the facts. You're misapplying. It's like having a skill, you know how to drive, but there is no car. So we don't know whether you can drive or not. So it is important for you to do that. So those are the areas I felt we needed to improve. But like I said, you all did well. The fact that you showed up, notwithstanding the short notice, actually even as the judicial officers were taken by short notice. So that in and of itself is a success. The rest is background noise. But don't treat it as noise, because it is what you need in practice. And for some of you, I'm made to understand that your time to practice comes not later than 5 years from now. So you should be ready. I want to give you just a few words of encouragement as you go now to your oral segment of this Moot. A study was conducted so many years ago, and the researcher concluded that 75% of people are afraid of speaking at funerals. Someone would rather be in a coffin than give an eulogy. your time is now. Please don't be like a person who is afraid of speaking at a funeral. Certainly you're not dying and no one is dead. You're just presenting a case. So you should be yourself, own up to your personality. I know we have so many inspirations, we have so many people we look up to, and sometimes we tend to speak like them, to walk like them, sometimes to eat like them. When you mar yourself in that confusion, you will fail to know who exactly you are. And for this moot, our main interest is who you are. Who are you? Because the assessment is to see how much progress have you had as a law student before you're churned out as a lawyer to practice law as it is. So please not be yourself. Do not lose yourself in the excitement. I see there are so many smart people here, so don't lose yourself in the excitement and all. Remember, you're the man or woman in the arena. There is no one outside there. It is you. So whoever, just know for us, we are just assessing you, but it is you who is in the arena who will bear the wounds and all. Hopefully there are no wounds for you to take. Lastly, like Esther said, she said that being knocked out is not the end. I wish to add that it is the beginning of an exciting career. So please don't sulk when you're knocked out. Don't feel bad. Don't think the judges are against you or even the world is against you. No, it's just a phase. We are 14 teams. Unfortunately, we shall have one winner. But in the end, like I said, we are all winners. The fact that we showed up and we are ready to face off, that should be a motivation in and of itself. So I thank you for your time and I wish you the best. May the best team win. Thank you.
I'm sure you guys are tired of seeing our faces and tired of the speeches, so now is the time. Kindly move to the back, check out where your team is and go to your room. It has been set, just go there, take your seats, and the judge will find you. Okay? Good luck to all the CLMs today. If you need any help or guidance, just reach out to me. The rooming list is there. If you don't know where your room is, ask us, we shall guide you there. The schedule is right there.
Federal Republic of Moemba in the High Court of Moemba at Moemba. Miscellaneous cause number 1 of 2025 between Aweri Health Lawyers Initiative and Muyodi Juliana applicants against the Attorney General and Light of Grace Medical Center as respondents. Judge Ivan Busura presiding. This court is now in session.
Hey, sorry. Please don't be. It's okay to be scared, but it's not helpful. Yes. So I think we all know the rules. If we play by the rules, we shall be okay. We shall save time and we shall earn marks. Yeah. So as we know, the applicants have 20, respondents 20, rejoinder 5. Okay? It's okay to pause and wait for questions. Actually, you must pause and wait for questions. When I interrupt you, the intention is not to knock you off balance, it is to understand you. Okay? So don't take it out of context, take it in good faith, okay? Because your arguments must flow. Okay? So in order to save time, informally, I'm going to just ask you for your names, then you will introduce yourself when you're going on, just for okay. Yes, so like I was saying, I need to record your names first, then we start, okay? Who are the applicants? You're the ones, okay. What's your team name? CLMH. Who will be the first speaker? What's your name? Serunjoji. Suvi. Aubrey. Aubrey, A-U-B-R. Okay. What about you? Who? Masoko. Okay. What about you? Who will be the first speaker? You. Which team is that?
CLMA.
CLMA. What's your name?
My name is Ruth Namirembe Hills.
Ruth Namirembe.
Hills.
Kindly spell that for me.
Hills.
Okay. Sir?
My name is Musoke Samuel.
Okay. Okay. That was informal. Now court, like he has said, is in session. For the record,
May it please this honorable court, for purposes of record, my name is Ruth Namirembe Hills, appearing as lead counsel with my ably assisted learned friend, co-counsel Samuel Musoke. Together we'll be representing the respondents from the Attorney General's office. And as the Attorney General's office, I would like to take the pleasure to introduce my fellow learned friends who will be representing the applicants. As lead counsel, we have Counsel Serunjoji Subi Aubrey and co-counsel Masoko Kristen.
Good morning. Good morning, my lord.
good morning.
May it please this honorable court, I am Aubrey Subi Serunjoji, appearing with my colleague, Ms. Christine Masoko. Together, we represent Aweri Health Lawyers Initiative and Miodi Juliana as the applicants. I will use 10 minutes of this court's time to address the preliminary issue concerning jurisdiction. I'll address issue A and B, while my colleague will address issues C, D, and make the prayers on our behalf. May I proceed?
How many minutes are you planning on using?
I will use 10 minutes.
She'll also use 10 minutes.
Yes, we shall reserve 5 minutes for rebuttal.
Okay.
May I proceed? I will now proceed to address a preliminary issue on this court's jurisdiction to hear the matter. This matter is arising out of Article 50 of the Constitution of this land, which provides that any person who states that there has been a violation of their right that is guaranteed under the Constitution in Chapter 4 may apply to this court to seek redress and orders in order to address their violations. If I may proceed, I seek leave of this court to make my opening statement. My Lord, does the state have any authority whatsoever to determine what a woman does with her body? Section 152 of the Penal Code Act of Muwemba, last revised in 1999, only serves the purpose of denying women access to essential life-saving commodities, thereby denying them the right to self-determine what their bodies are capable of. It dehumanizes them and it relegates them to a subhuman function in society where the system chooses what they cannot do. My lords, it is not surprising, therefore, that over 8 lives are lost because the women in society cannot choose what they believe is the best for them. I will now proceed into the substantive issues with issue A, whether the state's failure to ensure that emergency obstetric care is provided through government-funded hospitals violates the right to health and human dignity. Under this, I have 2 heads of argument. 1, Light of Grace Medical Center's government-funded status creates liability and responsibility for its constitutional violations of the rights enshrined in Chapter 4 of the Constitution. Indeed, applicant avers that Light of Grace violated the rights of Muyodi by denying her access to these very essential life-saving commodities. My Lord, under the national objectives and directive principles on state policy, the state shall endeavor to provide the healthcare services to the people. This is provided for in Objective 14 and Objective 20, effectuated by Article 8A of the Constitution of this land. Article 12 of the International Covenant on Economic, Social, and Cultural Rights provides that the people have a right to health care. My Lord, the right to health care should not be regarded as simply being healthy or the absence of disease and infirmity. It entails a range of aspects that promote the general well-being of a person, and this is according to the World Health Organization. General comment number 14 on the right to health, that is under Article 12 of the ICESA, provides that access to sexual reproductive health care is essential in ensuring that the people live a productive and vibrant life. According to the facts before us, my Lord, the state of Muwemba has allowed religious doctrine to override law and reason by impeding access to the essential elements such as life-saving treatment that Muyodi Juliana sought. This violates not only the constitutional secular principles, but also allows private actors to violate the right to health. Justice Cheborion, in the 2020 decision of Sehad and 3 others versus Attorney General, was of the view that emergency obstetric care services are essential.
Which court was that?
This was at the Court of Appeal, my lord.
Okay.
Justice Cheborian stated that the right to health care constitutes an immediate obligation, and therefore the state must be in position to provide these services without any excuses. Whereas respondents may aver that there are several conflicting obligations that it has to meet, my lords, the right to health, the right to life is an inherent right. It is non-derogable. Under no circumstances whatsoever can the state limit the rights of an individual in the exercise of general rights of the public. The state cannot say that it is promoting the right to religion while somebody was losing their life. I therefore implore this court to find that Light of Grace Medical Center violated Miodi Juliana's right to the highest attainable standard of physical and mental well-being by denying her access to emergency obstetric care, as was affirmed by Justice Cheborian in the 2020 decision, and that this denial resulted into Miodi Juliana being subjected to immense pain and suffering and torture. My lords, I implore you to consider the state that this young girl was in. The state of Muwemba has allowed religious institutions to dictate public policy that has concealed crucial information to their access to healthcare, to access information regarding contraceptives. If Miodi Juliana had been aware that this quick fix pack would actually result into her losing the ability to have a child in her life, I do not believe, my lord, that Miodi Juliana would have taken this pack. This only happened because she did not know that abortions are dangerous. This only happened because the state has not provided information regarding sexual reproductive health care, because it has allowed religious institutions and organizations such as Light of Grace Medical Center to do as they please, my lord. I pray that this court finds that Light of Grace violated.
How has the state allowed them to do as they please? Is it by commission or omission?
Much obliged, my lord. The Religious Institutions Regulations Act of Muwemba, established in 2003, limits government oversight over these institutions, and therefore the state has limited interference over what goes on in these health centers. It cannot implement the necessary laws that ensure that the people have access to sexual reproductive health care and emergency obstetric care. Can I proceed? Section 152, my lord, denies the women and girls in Muwemba from accessing the essential life-saving commodities by criminalizing access to safe abortion. As I stated earlier, had Miodi Juliana perhaps received safe medical abortions, she would not have suffered such torture and inhumane treatment at the hands of Light of Grace. I will proceed to my second issue, issue B, whether the dismissal of Miodi Juliana basing on her pregnancy and its termination is a violation of her right to the highest attainable standard of physical and mental health. My lords, Pokot University has a policy that singles out women in society, and it terminates their scholarships if there are on any. It pushes them out of school if there are on any. Article 33 of the Constitution provides that the state shall take into account the unique and natural maternal functions of women in society. My lord, the men in the state of Muwemba can never conceive a pregnancy. This policy will never at any one point apply to them. This policy only targets women and young girls, and it singles them out for their ability to have children, and it pushes them out of school, and it denies them the right to education provided for under Objective 18 of the National Objectives and Directive Principles on State Policy. It is discriminatory, and it violates their right to education and the highest attainable standard of education, as well as mental well-being. Miodi Juliana was stigmatized. Miodi Juliana was abused by the members of her community and her school. Secondly, when the university was terminating her, it did not observe the provisions of a right to a fair hearing in judicial and administrative decisions. They simply heard of the rumor on social media and They decided to terminate her. They did not call her to ask, how did this happen? They did not bother looking for Davis, the aggressor. They simply found it prudent for them to push her out without hearing her case or anything that might have led to her predicament. This doesn't solve the problem that Mary Juliana was faced with, and it is discriminatory and a violation of her rights guaranteed under the Constitution. Therefore, my Lord, I pray that this court finds that the termination of her scholarship and the suspension was unlawful and it was in the violation of the constitutional guarantees of gender equality as well as the right to a fair hearing. If I am of no further indulgence to the court, I yield the floor to my colleague.
May it please this honorable court, I am Masoko Christine, as earlier introduced by my co-counsel, Serunjoji Obre, the second applicant representing Muyodi Juliana and Aweri Health Lawyers Initiative. I'm going to address this honorable court in 10 minutes on issue C and D. Issue C is whether the state's failure to enact policies and laws in regards to protection of women from unsafe abortion has led to increased maternal mortality in the state. And we as the applicants submit that yes, the failure of the state to enact policies and law has actually contributed to the increase in maternal mortality in the state. My lords, the state, under my first head of argument that it is that limited resource allocation towards reproductive health care and health care in general has actually contributed to the increased number of maternal mortality in the state. My lords, the state has a duty to provide human rights to the people. It is the primary protector of the human rights of the people as provided for in Article 20 of our Constitution. Objective 14B and Objective 20, as put into enforcement by Objective 8A, provide for health care for the people of the state. Article 12 of the International Covenant of Economic, Social, and Cultural Rights that I will from now on proceed to call the ICESA provides for the highest attainable state of health rights for the people in the state. The applicant, however, recognizes that the provision of rights is actually subject to the limitation of the adequacy of the resources in the state as provided for in Article 2 of the ICESA still. The applicant, however, invites this honorable court to consider under the case of Purohit and Mo versus Africa and Gambia, Communication 241, that provides for the state to provide human rights to the maximum. However, consider provision according to the minimum core obligations provided for in General Comment number 14, that are availability, accessibility, adequacy, and quality. We submit before this honorable court that under paragraph 16 of our facts, that the state actually fails at provision of availability, accessibility, and quality, as government institutions are inadequately staffed, and there are no facilities to provide for women the highest quality of reproductive health. The applicant also submits that this is actually a strategic omission. Yes, please.
Did you say there are no facilities?
I said there are limited facilities for the women.
Okay.
Yes, please. The applicant also submits that this is a strategic action taken by the state because they believe in religious doctrines mostly before they put the rights of the women ahead as provided for in paragraph 8 of our facts, as they only consider religious doctrines based on the dominant religions in the state. My lords, yes, the state provides for national sexual education. However, they do not implement the policies that they make. They are merely hiding under the umbrella of progressive realization. However, these are policies that they are making that they are not putting into enforcement. Progressive realization calls for active for active achievement of strategic actions that will actually implement a given policy, especially to vulnerable groups, provided for in the case of Purohit and more still, and the Africa and Gambia. Communication 241. However, the state ignores that women actually need emergency obstetric care. The state provides for, under the Religious Institutional Act, that hospitals or institutions can follow their religious doctrines as long as it doesn't go against the federal law. However, these institutions are actually going against federal law. Light of Grace Medical Center does not actually provide post-care services as provided for by our federal law. Light of Grace Medical Center does not actually provide for abortion in cases of emergencies. And yet under paragraph 8, our federal law provides for abortion in cases of emergencies. So why exactly is the state failing to implement its own policies? Yes, it calls for, yes, the state argues that it is developing the reproductive care guidelines. However, my lords, how far should we wait for the women to die before the state actually puts into action the reproductive care guidelines? The case of Sehad versus Nakaseke Civil Suit number 111 of 2012 provides for achievement of emergency obstetric care, which is also not provided for by the state, or if it is provided for, it is limited, and limited only to what they consider moral as per the religious doctrines. We therefore pray that the court orders the state to put into implementation the existing laws and also provide policies that are going to be able to curb maternal mortality in the state and provide for safe abortions. My lord, under my second head of argument, that the state's religious provision of the right to reproductive health care has contributed to maternal mortality. My lord, reproductive health care entails achievement of information about your reproductive health. It entails provision of contraception. It entails emergency obstetric care as provided for in the Protocol of the African Charter on Human and People's Rights on the rights of women in Africa. That is Article 14.1. However, the state in paragraph 14, paragraph 11, fails to actually provide even the minimum of sexual education to these people. And yet the state reprimands them for getting pregnant and reprimands them for getting abortions. How is a woman who's not getting contraception able to control her body? How is a woman who's not getting sexual education able to know that I am not supposed to go for an abortion, or this is what happens when I practice sex? These are women that are actually ignorant, like Muyodi Juliana. She has no basis of sexual education at all. She's from the village. So how exactly is she supposed to know that when I participate in, maybe if I get a drink from someone, I'm going to be raped? Muyodi Juliana is a rape victim, my lords. We need to recognize that. However, she's subjected to the laws, moreover, religious doctrines that she might not follow, and yet the state calls for secularism. My lords, I proceed to my issue D. I beg to proceed to my issue D. My issue D, under issue D, it calls for the state's failure to provide equal access to education and healthcare services because it provides these services on a basis of religious doctrines. My lords, the state claims that it is a secular state. Secularism is defined as the ability of a state to make policies independent of religion. This is the, yes, please.
No, proceed.
Okay. This is defined under the Transitional Human Rights Review, Volume 1 of May 2014. My lords, the state is actually failing to recognize its own federal law, because if it states that it is providing for policies independent of religion, then why exactly is it letting 60% of the institutions be run by religious institutions that are implementing religious doctrines that are also against federal law, and it is not taking care to actually enforce its own law in the Religious Institutions Act?
So you would rather those institutions close? You want them closed? What do you want the state to do with them?
We do not call for the closing of institutions because they are actually needed in our society, because they are providing health care. However, what we seek as the applicants is that these laws are able to are able to run basing on the policies provided for under federal law.
You said these institutions are there.
Yes, please.
And they are being run in a manner that, in your own words, violates the rights of the citizens, right? The policies that they have.
Yes, please.
And here you are accusing the state of slacking, right?
Yes.
So what do you want the state to do with those institutions? Because you have also said that these institutions are good because they provide health services to the citizens of the state. So what should the state do?
My lord, the state should not call for closing of these institutions. However, we as the applicants are stating that the state should enforce the Religious Institutions Act, that states that in case the religious doctrines are going against federal law, then the state should call for review of their policies so that they can actually provide for facilities to the people as per the federal law that is in the state. I beg to proceed.
Okay.
I beg to proceed to my prayers, if I'm not no further indulgence. Considering our submissions, my lord, the applicants pray that the court, by the power granted by Section 33 of the Judicature Act, is able to order that Muyodi Juliana's scholarship is reinstated, that the court orders reinstatement, that the court orders constitutional compliance of the institutions existing in the state, and that the court orders the implementation of policies that are existing in the state and also makes policies towards achieving proper healthcare guidelines.
Okay.
I beg to submit if I'm of no further indulgence.
Thank you very much. The respondents?
Much obliged. For purposes of record, once more, my name is Ruth Namrembe Hills, lead counsel, and your lordship, our submissions will be within the allocated 20 minutes, whereby I'll be using 10 minutes for my submissions on the statement of jurisdiction as well as the first two issues, whereas my co-counsel will reserve the same 10 minutes for the last two issues as well as the prayers, whereby 5 minutes will be saved for rebuttals. With your leave, my lord, I would like to proceed to highlighting on the statement of jurisdiction, of which the respondents indeed concede to that we are before this competent honorable court pursuant to Article 50 of the Constitution of the Federal Republic of Moemba, as well as Sections 3 and 4 of the Human Rights Enforcement Act of Cap 19. Moving on, I shall now proceed to my resolutions, my lord, for the first two issues. And the first issue reads, whether the state's failure to ensure emergency quality obstetric medical services by government-funded hospitals violates the right to health. My lord, in line with Articles 45 of the Constitution, as well as Objectives 14 and 20 of the Constitution, we do indeed acknowledge the right to health and, of course, the obligation of the state to ensure this right to health, as also highlighted under Article 16 of the African Charter on Human and People's Rights, as well as Article 2 of the International Covenant on Economic, Social, and Cultural Rights, of which do impose these obligations and of state parties, especially to take all necessary means of progressive realization within the available resources, including the adoption of legislative measures. The respondents have argued on the matter that the state limits the right to health, my lord, and this has been elaborated by the respondents in the matter of where Moyodi Juliana was apparently denied access to sexual reproductive health services. However, I would like to draw this honorable court's attention to paragraphs 24 of the fact sheet, whereby the government does not refuse for these services to be provided for by, to citizens of Moemba. As we can see under paragraph 24, We Care Hospital does exist, and We Care Hospital did indeed offer these services to Moyodi Juliana in a state of emergency, in a state where her life was at risk, which is also provided for under sections 152, as the applicants did mention, of which states that medical abortions or medical healthcare services should be provided for in a state of where the mother's life is at risk, of which the state or the respondents did provide for. I would like to highlight on the issue mentioned about Juliana being in immense pain and the fact that the respondents failed to ensure her right to health was protected. However, I would like to draw this honorable court's attention to paragraph 20 of the fact sheet, of which shows that Juliana was indeed aware of the risks of these kinds of quick fix packs or these kinds of quick fix services for abortion. As seen under paragraph 20 of the fact sheet, it shows that Juliana was indeed aware of some newspapers, of articles, of certain sources. She could access this information that there were so many services that were really unhealthy and would put her at risk during if she succumbed to these kinds of services. And I would like to remind this honorable court that an abortion isn't just a quick fix matter at hand.
So in short, what you're saying is that you as a state do not have any obligation whatsoever to provide information to your citizens on how to handle their health matters, including reproductive health. Is that what you're saying?
Much obliged, my lord. That is not at all what we're saying, because if you look at paragraphs 11, the state has found so many ways of implementing or of upholding these obligations. And according to paragraph 11, there have been regions that have implemented sexuality education and access to this information. However, the applicants did mention that Moyodi was not able to access this information, but I would like to ask the applicants how they are aware that Moyodi Juliana's region was not part of these regions of which offered sexuality education.
So in short, you're saying you as a country, you have an obligation or you have a policy, a sex education policy. Do you?
Much obliged, my lord. We do have a sexuality education policy that was indeed established by the National Framework Forum of Sexuality Education in 2016.
Okay.
Much obliged. Furthermore, to highlight on the issue of the Religious Institutions Act in the state of Moemba, this only applies to faith-based institutions as seen under paragraph 14 of the fact sheet, and the fact that Moemba is a state that has been built upon religion from Islamic grounds and Christianity grounds, this shows that some of these entities, of course, have to uphold these religious and cultural norms where required in certain institutions, my lord, and this does not provide for all the institutions within the state of Moemba. This is only for the faith-based institutions. Juliana, the first applicant, decided to go to We Care Hospital to retrieve these services for medical abortion. However, there were many other institutions as well that could provide for these services, but she resorted to going to Light of Grace Care Medical Hospital. And this is what resulted, which is a faith-based institution, may I add, and therefore was denied of these services, as rightfully so under the Religious Institutions Act. However, We Care, for example, provided to her even more than was needed. She had quality medical abortion services as well as post-care services. And she was also instilled, and she was my apologies, she was always kept looked after even after the abortion. Moving on to issue 2 of my submissions on whether the dismissal of Juliana violates her highest attainable standard of mental and physical health from Pocot University. I would like to draw this honorable court's attention to Articles 20 and 21 of the Constitution, of which states that all persons are guaranteed equal under the law and obliges all government organs to uphold these rights of health and freedom of discrimination, among others. The applicants are holding the state liable for the violation of right to health and freedom from discrimination by Pocot University based on this constitutional provision. However, I would like to draw this honorable court's attention to Section 23 of the University and Other Tertiary Institutions Act of 2001, under Section 23, of which asserts that Pocot University is considered its own entity as a separate body corporate due to its accredited nature, therefore giving it the capacity to sue and be sued under its own corporate name. Similarly, under Sections 10 of the Human Rights Enforcement Act, Cap 19, it also asserts that public officers can be held personally liable for their violation of rights. The first applicant was dismissed from Pocot University on grounds of indecent conduct from an institution that can create its own policies, among others. Therefore, the university's decisions shouldn't be held attributable. They shouldn't be held, the state shouldn't be held against the university's policies of what they make, because they are an accredited institution and they can lawfully make these policies.
So in short, you're asking, why are we here as the state?
In short,
yet the actual culprit is out there.
Much obliged, my lord. That is exactly
what
the state is asserting. Because why would the applicants hold the state responsible or attributable to the violations of the university dismissing Juliana on grounds of indecent conduct? The university is not even a part of the respondents in this matter, my lord. It is only the state and Light of Care Medical Hospital. Therefore, your lordship, the respondents therefore submit in the negative, as the dismissal of the first applicant from Pocot University does not constitute a violation attributable to the respondents whatsoever. With this, my lord, I would like to hand over the stand to my co-counsel to adduce on the last 2 issues.
May it please your lord, I am Samuel Musoke, appearing as the second counsel for the respondents from Attorney General Chambers. My lord, I'm here. My lord, I would like to address 2 issues before this honorable court, issue 3, issue 4, and lastly, I will state the prayers the respondents are seeking from this honorable court. Unless there is any question from the bench, I'm ready to proceed to my 3rd issue.
I would ask questions. Proceed.
Okay. My 3rd issue says that whether the failure of the first respondent to enact laws and policy framework to facilitate safe abortion violates the right to life. My lord, pursuant to Article 20 of the Constitution of the Federal Republic of Moemba, it dictates that it is the duty of the state to uphold, respect, and promote human rights. Additionally, national objective and state policy and state principles of the state policy, specifically Objective 14, read together with Objective 20, dictates that it is the duty of the state to ensure practical measures and provisions and accessibility of basic medical services. Furthermore, Article 33 of the Constitution of the Federal Republic of Mwemba provides that it is also a duty of the state to promote human rights, to promote the rights of women, taking into account their unique status and maternal functions. However, to this effect, we submit that the first respondent has ratified several international human rights instruments, including the International Covenant on Civil and Political Rights, African Charter on Human and People's Rights, the Maputo Protocol, among others, as provided for under paragraph 6 of the facts at hand. Article 2, Clause 1 of the International Covenant on Economic, Social and Cultural Rights dictates that state parties should ensure the progressive realization of economic social rights, and among others includes the right to health by utilizing the available resources of that state. Relying on the decision in Prohit and another versus Gambia, 2003, brought before African Commission on Human and People's Rights, the African Commission emphasized that progressive measures to realize the right to health and life do not demand immediate protection, but rather concrete steps towards availability and accessibility of the social and socio-economic rights. My Lord, pursuant to paragraph 24 of the facts at hand, the respondent submits that the first respondent has hospitals that provides a range of these services. For example, Wikea Hospital has these abortion services, and Muyodi Juliana, when she approached them, Wikea Hospital was able to provide emergency treatment for the abortion complications, post-abortion, and also advised on which drug to use just in case a similar situation happens in future. Paragraph 29 of the facts at hand also shows that while maternal mortality remains 370 per 100,000 live births, the first respondent has also emphasized that it introduced maternal health programs. For example, paragraph 3 of the facts at hand shows the budget allocation as 5% allocated to health, and also reproductive care guidelines, which are yet to be passed. Paragraph 30b also indicates that the first respondent has made development on reproductive care guidelines to provide emergency reproductive health care and post-abortion care services.
So, just stopping you right there. According to you, with the obligations you have in the international instruments and the budget allocations you have made and all other measures you're hinting at, do you think your commitment to the health and well-being of your citizens is okay?
Much obliged, my Lord. In response to your question, yes, we acknowledge the fact that our budget allocation to health is 5%, but 6% of this budget is taken to reproductive health care services. And as I earlier...
6% of the 5?
Yes.
No, my question was,
yes.
Okay, let me ask directly. Is 5% enough? 5 out of 100?
Much obliged, my Lord. It is not enough, but relying on the principle of progressive realization, and because it dictates that we have to utilize available resources to ensure that socio-economic rights are realized.
No, but this is now percentage-wise.
Yes.
You have 10, you have 100, you've given 5.
Yes.
That is why I think progressive realization would be quite problematic for you to pull off as the state.
Much obliged, my Lord.
So, is it a game? That is what I want to ask.
Yes.
Do you have any explanation as to why you have chosen to give 5%,
Yes.
as opposed to 6
Much obliged,
or
my lord.
anything more than 5.
Much obliged, my lord. Yes, we do have an explanation to that, and it is this. First of all, the backbone of the Federal Republic of Moemba is agriculture. And pursuant to paragraph 1 of the facts at hand, it gets almost 42% of its GDP, gross domestic product, from agriculture. And this budget allocation of 2025-2026 was allocated on health as 5%, then on agriculture as 20%, and education as 28%. There is no way we can allocate the total budget to health, or even 90% to.
So,
yes.
so in short, you are better off having food than a healthy population. Is that what you are saying?
Pardon?
That because your backbone is agriculture, so you would rather invest more in agriculture while you have poorly looked after human beings in your country.
No,
without their health guaranteed.
Much obliged, my lord. We submitted as the respondents. We wish to allocate a heavy budget on health in the next financial year, because we have the responsibilities as the Attorney General.
Okay, proceed.
Okay. Much obliged, my lord. Persuasively on the issue of progressive realization, we also rely on the decision in Sehad versus Attorney General and National Medical Stores miscellaneous cause number 30 of 2023. My lord, this was a miscellaneous cause brought before court on the issues that the National Medical Store delayed in distribution of drugs. The respondent in this case, who was the Attorney General, brought the Honorable Court's attention to progressive realization, and he stated that because of the limited resources of the state, the Attorney General was representing, it managed to utilize its available resources, and the court regarded this miscellaneous cause as a mere one. Rather, Justice Dr. Douglas Kalekola.
I didn't get that. It regarded it as what?
Yes?
I didn't get that. What did the court do?
Okay, the holding of the court. The court dismissed the miscellaneous cause. But while dismissing...
No,
yes.
You are developing the argument. I'm interested in what court concluded on the argument that you are saying. On the question of miscellaneous progressive realization.
Okay, the conclusion.
What did the court say?
The conclusion of the court was, court stated that sometimes it is helpful for the people to appreciate the facilities and measures of the government that have been put in place to ensure that their rights are realized. And in that case, Justice Douglas Kalekola Singiza held that, to that regard, the respondent, who was the Attorney General, managed to fulfill its obligation to realize the socio-economic rights.
Okay.
In conclusion, we submit that the first respondent did not fail to enact laws and policy framework to facilitate safe abortion. I would like to proceed to my fourth issue.
Okay, proceed.
Which states that whether the failure by the first respondent to guarantee equitable access to sexual reproductive education and health care services violates the Constitution.
I'm giving you an extra minute because of the interruptions.
Much obliged, my lord. My lord, pursuant to national objectives and state policy 14 read together with 20, it is the duty of the state to take practical measures to ensure equitable access to basic medical services by all persons. Article 21 of the Constitution of the Federal Republic of Moemba guarantees equality for all, and prohibits all forms of discrimination. However, we submit that paragraph 13, line 3 of the facts at hand, shows that the Ministry of Education, together with the Ministry of Health, have implemented phased measures towards achieving universal access to social reproductive health rights, education towards the health sector that remains below 6% of its budget. Paragraph 11 of the facts at hand also shows that national framework for sexuality education has been implemented in 9 regions of the Federal Republic of Moemba. Therefore, we also acknowledge that we also disagree on the applicant's submission that the religious institutions influence the religious dogmas of Moemba, influence its legislation. We, as the respondent, we have constitutional courts situated in Impanda, which is the capital city of Moemba, which can hear matters concerning constitutional interpretation. We submit that had the applicants brought these issues before the constitutional court, the respondent would be able to respond and to resolve the same. My Lord, I can see that my time is up, but I request for discretionary 20 seconds to state our prayers.
Okay, you conclude.
Okay.
Yes, your prayers in 5 seconds.
Much obliged, my Lord. To this regard, the respondents submit that this honorable court finds issues 1, issue 2, issue 3, and 4 to be answered in the negative, and this application be dismissed.
Okay, thank you so much. Do we have any rejoinder? How are you apportioning it? Are you responding? You're the only one who's going to respond because you have 5 minutes. Okay.
Much obliged, my Lord. Before I begin, I'd like to offer some further elucidation on issue C that my colleague was addressing with regards to religious institutions.
No, when you do that, it means they will have to give us a rejoinder, where we don't have that time.
All right. First, the Attorney General of the state of Moemba stated that Muyodi Juliana acquired the services that she sought from We Care Private Hospital. But this hospital, my Lord, is several miles away. If you look at paragraph 24 of the facts, they went there the following day. They arrived shortly after midnight. This hospital is private. It has no government subsidies whatsoever. So it is expensive for a person like Muyodi Juliana, who is merely a student. Under the elements of sexual reproductive health care, these services should be available, they should be affordable, they should be accessible, and they should be of the highest quality, my Lord. This is provided for in General Comment number 14 on the right to General Comment number 22 on the right to sexual reproductive health care. Similarly, the Attorney General of the Republic of Moemba stated that Pokot University is a university that is not party to this suit. However, I'd like to persuade this court, relying on the principle in the University of Lagos versus Igoro, where a court was of the view that these rules can only be enforced so long as they do not violate the rules of rationality and are not enforced in an unlawful way. The university did not give Muyodi an opportunity to hear her case under Article 42. The university enforced a policy that is discriminatory and targets women alone. The pregnancy should not be a ground for termination and suspension of a person on a government scholarship. The university is also a public institution and the government is liable. In the case of Sehad versus the executive director of Mulago Hospital and the Attorney General, this is 2000 and...
It's okay, just
2013.
It's fine.
The court held Mulago Hospital liable for the loss of lives and the children that went missing at the hospital, and the state was directed to take measures to ensure that these are rectified. Similarly, in Velasquez Rodriguez versus Honduras, the Inter-American Court on Human Rights opined that the state has an obligation to ensure that the rights of individuals are not violated by private or non-state actors. In this particular case, the state has an obligation to ensure that institutions such as Pokot University do not violate the rights that are provided for under the Constitution of the Republic of Muemba, as well as various regional and international human rights. My Lord, the second respondent, counsel for the respondent argued that the state has provided 5%, but my Lord, according to the Abuja Declaration, state parties, which Muemba is a party to this declaration, provides that state parties should provide at least 15% of their national budget to the health sector. According to our facts that we have, paragraph 13, the state has consistently allocated only 6%, and it has allocated over 32% of the national budget to defense for a country that is not even at war, my Lord. They are not progressively realizing, they are not even attempting to realize the right to health care. Because when you allocate 32% to defense, when nobody is fighting the country, yet 5% to health care, where 8 lives are lost per day simply because religious institutions do as they please, this is a cost that is too great to simply be allowed to continue. 8 lives is such an extreme cost that has to be paid for people to enjoy their right to worship. Therefore, I pray that this court finds that the state is liable for the violation of Miodi Juliana's rights, as well as Pokot University's suspension should be overturned, and a scholarship should be reinstated. If I have no further indulgence, I yield the floor.
Okay, thank you. Do you have anything to respond to what they have said for assessment purposes? Because I want to assess you on your response.
On my response.
Anything you want to respond to, because the presumption is you are listening.
For assessment purposes.
Yes.
My Lord, as earlier on introduced, I am Masoko Christine, still here to respond to the respondents. My Lord, the respondents placed an argument of progressive realization, and they stated that they are achieving reproductive health care through providing the 5% reproductive health care and reproductive care guidelines. However, my Lord, as I was stating my arguments, I stated that the state is actually... Okay.
Now, let me help you on what to respond.
Yes.
For him, he said that as a state, they have committed that next year they are going to add. What do you respond to that?
My Lord, under the facts, we recognize an implementation problem of this state. Yes, the state may say that next year they are actually going to recognize these rights. However, paragraph 11, they brought in the national education, sexual education in the curriculum. However, it is not being implemented and the state is not doing anything about it. Paragraph 14, the Religious Institutional Act, they brought in the fact that as long as institutions go against federal law.
No.
Yes, please.
This is an allocation question.
Yes, please. Allocation.
It is allocation, not implementation.
Okay.
Allocation is what I want you to restrict yourself onto.
Okay. My Lord, towards allocation, yes, the state is stating that they are going to provide more allocation in the next years towards achieving reproductive health care. However, which steps are they taking to ensure that they are actually going to provide a higher percentage in the budget for healthcare? Because as represented in the facts, it seems the state is actually comfortable towards provision of the rights to reproductive healthcare. They are comfortable with the fact that the state should receive 32% of security in a state that is actually not suffering civil war, and they are comfortable with the fact that agriculture should get a high percentage. They are comfortable that 8 women are dying per day, as long as they are taking their sweet time to actually recognize the reproductive care guidelines, which my lords is taking them a long time to implement. Apart from the reproductive care guidelines, what else is the state trying to do to actually achieve increase of the 5% in their budget?
Okay.
If I'm of no further indulgence, my lord, yes, I beg.
Thank you so much.
I beg to submit.
Thank you. Please clap for yourselves. So I'm going to take just a minute to tabulate and then give my feedback. Thank you. I'll start with the positive comments. First of all, congratulations for keeping time. It is not easy. So you are very good timekeepers. Positive number 2 is that you are not afraid to take on questions. That is a positive, but it can be a negative somehow, because it is a positive when you have the right answer. It is a negative when you have a wrong one. So if you have a wrong one, you are better off either conceding or saying nothing at all. Okay? So I congratulate you for that. The second positive is that you did good research. Your arguments were good arguments, and they would persuade anyone on whatever side they decide to take. However, I've noted a few, I don't want to call them negatives, but I would like to call them areas of improvement for you. One, please avoid presenting like you are on a theater performance. I could tell that some of you are here to impress the judicial officer. No, your role as counsel. Hey, sorry. I'll repeat because I didn't realize I was on live stream. So the positives I take out of this is that you were both sets. You are good timekeepers. Please keep it up. 2, you are not afraid of taking on questions. But like I said, it can be a positive but a negative at the same time. It is a positive when you give a correct answer or a persuasive answer. It is a negative when you give a wrong one or an answer which does not persuade at all, or one which confuses your arguments altogether. So you be careful while exercising that strength. However, like I said, there are some areas of improvement which I believe if you took on seriously, it would sharpen you into a good lawyer. Please avoid presenting like you're on a theater performance. Your role as a lawyer or an advocate is to persuade, not to impress. Okay? Persuade, not impress, stroke entertain. The platform for impressing and entertaining is theater. But in court, your role is to persuade, to buy the judicial officer to your side. In a follow-up to that, make sure at all times you own your submissions. Be real, wear your confidence as your armor to attack any moments of doubt in the mind of the listener, who is the judge. Please remember, the judge is the most important person for your client after you. So if you leave the courtroom without the judge understanding what you are saying, then your client might as well start counting their losses. So while you submit, please make sure you understand what you are submitting. I could tell some of you had something to say, but you didn't know what it actually meant. In other words, you are confused by your own submissions. So before you enter court or before you appear before a judicial officer, make sure you have your arguments offhand, right? Because you will be thrown off balance by the arguments raised by the other party, by the environment in court, by the intimidating nature of the judicial officer, because a judicial officer without saying something may remind you of quite a number of bad things, and you are thrown off because you don't know what you prepared for. You crammed. You don't know what you prepared for, and it will be quite hard for you and your client. The other thing I noticed is that you people like throwing provisions. The Maputo Protocol says this, then you quote. After doing that, please tell us the conclusion first before justifying. If you are saying that the Abuja Declaration requires states to allocate 15%, okay, of their budget towards health, you tell us what in your case, what the state has done, right? So the Abuja Declaration requires allocation of 15%, but the respondent has done this, right? The respondent has allocated 5%. So what some of you do is the Abuja Declaration allocates XXX, then you start telling us in paragraph this and this, we are lost, right? The other thing is that when you're citing collegial courts, collegial courts are what we famously call panel courts, Court of Appeal and Supreme Court. Please stick to the court itself. We are not interested in what the judge in that court said, because the most important thing is the court, okay? So when you're citing a panel of Ivan Busulwa and other judicial officers, please don't look at me alone, look at the court, what it said, because that is the position. Unless the decision you're citing is obiter, and it may be helpful in framing your judgment. But if it is the ratio of that decision, please stick with the court as your citation. Legal language. I heard words like sweet time. That the respondent is taking their sweet time. That language is alien to court. Like they say, that dog won't hunt. So stick to legal language. Also, there are some words that are actually legal, that actually cut the legal jargon, but they do not help you make your point. For example, the applicants were saying that government should interfere in the activities of the medical facilities. That is a good argument, but the word interference kills it. I would replace it with perform oversight role or regulate. It is the same thing, but different impact. Okay? Then, of course, I've already mentioned this, but I can't stress it enough. Cram work. Cram work is a courtroom evil. Please. Some of you crammed to the extent that you didn't realize I was only one judge on this panel. You kept saying, my lords, probably because your submissions were, and you didn't want to go off guard, to go off rail. Okay? So once you cram, then there is no originality in your submissions. Then the other thing is, once you have conceded to a prayer, that is it. Don't substantiate. I saw it in Hill's argument. You concede to jurisdiction, then you tell us Article 50, you're wasting your time because there is no ruling that will be made to that extent. Okay? Please remember this, that whatever you say in court, before you respond to something, ask yourself whether it will be relevant in the ruling that will be made. Okay? Then, please maintain eye contact. Some people are good with eye contact, others were not. By eye contact, I don't mean you should stare at the judge as if you're his next killer. No, eye contact, you should remember, eye contact is a sign of confidence, and it is an indication that you own that court. But you're also humble enough to maintain your cool, okay? So if you're talking to the judicial officer, but you're looking at the clerk, you're looking at that pull-up banner, you're looking at this thing, I don't know what it is called, right? So it is really hard for you to convince the judicial officer, because they really want to see. Remember what I said there. You're here to tell us who you are and to also show us who you are. Now, if you look aside, I will just be looking at a coward, period. Nothing else. A coward holding out as a lawyer. Okay? When you are citing a decision, please don't concern yourself with the submissions. In that case, you're wasting time and space. Okay? Go straight to what the court said. Unless the judicial officer, where the judicial officer agreed entirely and just said, counsel said this and I agree with him. Okay? But if that is not the case, go straight to the decision, because remember, you have 20 minutes to convince the judge. Then, you people love bombing court. You love bomb it with authorities. You make a point, give an authority, add another one, add another one, add another one. court is convinced, overly convinced, it is cooked. But you're wasting your time overcooking court, and yet there is more to cook it on. So once you give an authority, once you feel you've convinced enough, move on. Okay? Then I think that's just about it. But again, I want to congratulate you and say you are on the right course. Now, you all did fairly well, okay? Of course, especially noting that for some of you, this is your first time. This is your first time coming to settings like this. So you're expected to make mistakes, but those should not define you. They should not injure your ego if you have it, but they should not also affect your confidence if you don't have it. In fact, they should actually increase it. So these are the scores. Do you prefer me giving you the average, or you want me to break down what each of you scored? You want me to tell you what you scored individually and then the average? Okay. So, for Mr. Serunjo Jisubi Obre, you scored 59%. Okay. Then Miss Masoko Christine, you scored 67%. Then for Miss Ruth Namirembe Hills, you scored 65%. And for Mr. Musoke Samuel, you scored 69%. This is the average. CLMH, you scored 63, while CLMA, you scored 67. But like I said, this is just the beginning. If you are good at watching movies, translated movies, we would say Katandi Kaputandis. Yeah? The world is not ready for you. So court adjourned.
Please check for where you're supposed to go and go to that room. Dear students, welcome back from the preliminary round, the first one. Please and please, there's no time to sit and caucus. Kindly check the second round where you're supposed to be and go to your team. Those who are proceeding from here, please take up your seats. And those who are not supposed to be here, kindly check where you're supposed to go and go to your team room, please. Apart from the two. Those supposed to proceed in Sezibwa, the room is free now. Please go and get ready. Where are you supposed to be? Which room? CLM. You're not supposed to be No, no, you're CLM. You're CLM. You should know your CLM. You're going to night. Wait. Sezibwa. You go to Sezibwa. Janeja, is this? Why am I? Hello. CLMF, are they here? We talked about time management and timekeeping. Are you ready to proceed? Who are the applicants?
Miscellaneous cause number 1 of 2025 between Aweri Health Lawyers Initiative and Moyodi Juliana as the applicants against the Attorney General of the Federal Republic of Mwemba and Light of Grace Medical Center with Judge Ivan Busura presiding. This court is now in session.
Thank you. Good afternoon. How are we? You look beaten. Are you okay? Are you just too serious? Yes, so like you heard, my name is Ivan Busura. I'm going to be your judge for this session. The intention is not to threaten you. If you feel threatened, at least calm down. It's okay. Okay? So, like you all know the ground rules, we shall have 20 minutes for each session, for each team, applicants, respondents, and then 5 minutes for the applicants to give us their rejoinder. You're advised to split those 5 minutes between yourselves for each of you to be assessed on the response to the opponent's submissions. Okay? So please, sorry if it affects your preparation, but I know you will pull through. Okay? So unofficially or informally, I'm going to ask you for your names to put on my mark sheet, and then when you start, you can carry on with your flow. Is that okay? Okay. So who are the applicants? Okay. What's the team?
Team CLMF.
CLMF. What's your name? Will you be the first one to present?
Yes.
Okay.
Masolo Adrian.
Okay. Your Adrian is with an E or an A?
An A.
Okay. Thank you. What about you, madam?
Mirembe Linda Namlema.
Mirembe Linda.
Yes.
With a Y or an I?
With I and H at the end.
Okay. Thank you. Who will be the first one to present?
I'll be the first one to present.
Which team is that?
CLMB, respondent.
Okay. What's your name?
My name is Chitimbo Alison Faith.
Chitimbo?
Alison Faith.
Alison. Thank you.
My name is Naso Vogamasi.
Okay. Thank you. Now we can start. Please be confident. Don't fear. We are human beings, okay? Can start.
Much obliged, my lord. My name is Chitimbo Alison Faith, the Attorney General, pursuant to Article 119 of the Constitution of Mwemba, which vests the Honorable Court with the power to represent the state in all civil proceedings, together with the Deputy Attorney General, Nancy Bugamasi. The applicants are represented by Counsel Masolo Adrian and co-counsel Mirembe Linda. Much obliged, my lord. We pray to submit.
Much obliged, my lord. The case before this court is about a young woman, a student, whose dreams have been shattered, not once, but twice. First, by a student, a fellow student in Pokot University, who gruesomely raped her and who is still at school, while Muyodi is in this court battling for her rights. But secondly, by Pokot University, the very institution that she hoped would protect her, dismissed her and labeled her as immoral. My lord,
It is on this basis that we, as the applicants, are before this court to respectfully request you to uphold the rights of women, the rights of 8 girls in the state of Moemba that die as a result of lack of policies to ensure the right to a safe abortion. With that, my lord, I will proceed to address this court on the preliminary issue of jurisdiction. Article 50, Clause 2 of the Constitution of Moemba grants this court unlimited original jurisdiction to handle all matters, including those of human rights violations. This is also read together with Article 139, Clause 2 of the Constitution and Section 41, Subsection 1 of the Judicature Act. This was also stated in the case of Stephen Kalali versus Attorney General of 2022 at paragraph 22. It is therefore our submission that the applicants are rightly before this court, alleging violations of the right to health, the right to be free from discrimination, and the right to education. Having submitted on the preliminary issue of jurisdiction, I will now proceed to address this court on the first issue that deals with the denial of a safe pregnancy, a safe abortion by Light of Grace Medical Center, and we shall submit that this amounted to a violation of the right to healthcare services that includes access to sexual and reproductive health services that entails a safe abortion. And 2, that the state, in allowing Light of Grace Medical Center to operate on the strictly no abortion policy, which it relied on to deny Muyodi a safe abortion, violated its duty to protect the right to health. Regarding the first limb on the violation of the right to health care, in the state of Moemba, the right to health care has been made justiciable under Objective 20 of the National Objectives of Directive and Directive Principles of State Policy, read together with Article 45 and 8A of the Constitution. The state of Moemba has also ratified treaties that recognize this right, particularly Article 12 of the International Covenant on Economic, Social, and Cultural Rights, and Article 14, Clause 2 of the Maputo Protocol. This was also echoed by the Constitutional Court in the case of Sehad versus Attorney General of 2011 at page 18. It is the applicant's further submission that the right to health care shall include access to sexual and reproductive health services that entails a safe abortion. This position has been stated under Article 14, Clause 2 of the Maputo Protocol, and is also echoed under paragraph 10 of General Comment number 22 of 2016 on the right to sexual and reproductive health. My lord, in the instant case, paragraph 22 and 23 of the facts reveals a dire set of circumstances. Muyodi, a young girl going through post-abortion complications, went to Light of Grace Medical Center bleeding rapidly. But the hospital did not bother to even provide first aid, but dismissed her and even called her a sinner. It is our submission that this was a violation of her right to health care. Regarding the second limb, it is our submission that the state has failed in its duty to protect the right to health. Article 20 of the Constitution of Moemba requires all people to respect, uphold, and promote rights enshrined in the Constitution. Additionally, General Comment number 22 of 2016, particularly under paragraph 10, requires states to ensure that third parties like Light of Grace Medical Center do not interfere with access to sexual and reproductive health services by putting in place barriers to this access. But it also states that in instances where a state allows for conscientious objections, like the state of Moemba, it must require that if a hospital is not able to work on this patient, they must, 1, either refer the patient to another hospital, but 2, if the patient is in a dire state of emergency, they must work on this patient. This was also echoed by the Supreme Court in the case of Sehad versus Attorney General. My lord, in the instant case, the facts before you reveal the contrary.
What was echoed?
The fact that states must protect the right to health from being interfered by third parties.
the error, who was at fault in non-referral, that previous point you made.
Light of Grace Medical Center.
So is that the problem of the state?
It is our submission that this is a problem of both Light of Grace Medical Center, but also in the state, because the state is supposed to put in place guidelines that require medical centers like Light of Grace Medical Center to refer these patients to other hospitals. But also, when one is in a dire state of emergency, you must work on them. And in the instant case, Light of Grace Medical Center did not do so. So it is our submission that this was a violation of the duty to protect. Having addressed this court on the first issue, I will now proceed to address this court on issue 2 that deals with the dismissal of Muyodi from Pokot University that the applicants submit was 1, a violation of her right to be free from discrimination, and a violation of her right to the highest attainable standard of health. First, regarding the right to be free from discrimination, Article 21, Clause 2 of the Constitution of Muemba guarantees the right to be free from discrimination. This is also echoed under Article 2 of the Covenant on Elimination of All Forms of Discrimination against Women. It is our submission that differential treatment, similar to what Muyodi faced at Pokot University, becomes discriminatory where it is based on unjustifiable grounds and it was disproportionate. This is the position of the Human Rights Committee in the case of Zwan de Vries versus Netherlands of 1984 at paragraph 13. Whereas the respondents may argue that the treatment that was accorded to Muyodi by Pokot University was justifiable since she had violated the university's code of conduct, it is our submission that this is not the case. This is because differential treatment of women based on their pregnancy is discriminatory and unjustifiable. But also, the person who raped Muyodi, my lord, is still at university pursuing his 4th year, while my client is in this court battling for her rights. So if it was truly justifiable, why is the person who raped her still at university? Secondly, regarding
so you would invite this court to also dismiss that student?
Much obliged.
So that we are even, so that he is also out of school.
Much obliged, my lord. We would invite this court to compel the respondent to apply the university's code of conduct fairly and also require that the circumstances under which Muyodi was dismissed was unfair. I will now proceed to address this court on proportionality, and it is our submission that the dismissal of Muyodi was disproportionate as it fully impaired her right to education. The African Court of Human and People's Rights has stated in the case of Pan-African Lawyers Union of 2013 at paragraph 21 that a limitation of a right must not impair the very essence of a right. My lord, in the instant case, the facts reveal that Muyodi is from a poor family, and as a result of her dismissal, her government scholarship was also revoked. It is our submission that it is going to become impossible for Muyodi to return to school. It is therefore our submission that this was disproportionate, but also the African Committee on Welfare and Rights of the Child has stated in the case of Legal and Human Rights Center versus Tanzania at paragraph 55 that institutions can resort to less intrusive means to achieve their goals. And these include sexual education, peer-to-peer education, rather than resorting to extreme means like dismissal. I will now proceed to address this court on the second limb of argument under issue 2, that Muyodi's dismissal was a violation of her right to the highest attainable standard of mental health. As earlier submitted, the right to health has been made justiciable in the state of Muemba. Additionally, Article 12 of the ICESA, read together with General Comment number 22 at paragraph 2, states that the right to health shall include the right to the highest attainable standard of mental health. It is our submission that in the instant case, by Pokot University dismissing Muyodi, who was a victim of rape, violated her right to mental health as she was now subject to stigma. The Journal of Clinical Medicine on Adolescent Pregnancies by Vilnius University has stated at page 4 that stigma among adolescent girls is one of the highest causes of poor mental health. This has also been echoed by the African Committee on Welfare and the Rights of the Child in the case of Legal and Human Rights Center versus Tanzania at paragraph 109.1. My lord, in the instant case, the facts indicate that as a result of her dismissal, the professors at Pokot University could not even look at her face. Her family was disgraced by her actions. People in the village did not want to interact with her. My lord, this is a victim of rape. Meanwhile, the person who perpetrated this rape is still at university attending lectures as we speak. It is therefore our submission that the actions by Pokot University was a violation of her right to be free from discrimination and her right to health. We therefore pray that this honorable court, one, declares that it has jurisdiction in the instant claim, but also holds the respondent accountable for its failure to protect the rights of young girls in the state of Moemba. Having submitted on issue A, issue B, and jurisdiction, I will now yield the floor to my co-counsel to address this court on issue C and issue D. Thank you.
Judge presiding, opposing counsel, may it please the court. As earlier introduced by my co-counsel, my name is Mirembelinda Namlema, appearing as co-counsel for the applicant. My lords, this case does not only concern Moyodi Juliana. It represents thousands of women that are left to bleed and die in their houses and dormitories, neglected by the very institutions that were entrusted with healing, slut-shamed, pushed to the side by the institutions that were entrusted with teaching, and above all, abandoned by the very state that promised them dignity, equality, good health, and freedom from discrimination. Allow me to demonstrate this while addressing you on issues C and D. In regards to issue C, the applicant submits that Moemba failed to pass laws that allow women access therapeutic abortion, which in turn increased the maternal mortality rate, which was a violation of the rights to health and life of the women in Moemba. I will demonstrate this under two limbs of argument. That one, Moemba has failed in its obligation to fulfill the right to access therapeutic abortion, and secondly, that Moemba has failed in its obligation to respect the right to health by criminalizing abortion. Proceeding to the first of these two, the right to life is a fundamental right. However, it is interlinked with the right to health, and we shall center our submissions on the right to health as it is the primary avenue through which the right to life is realized. The right to health is recognized under the Constitution of the Republic of Moemba under Article 20, Clause 2, read together with Objective 14 and 20 of the National Objectives and Directive Principles of State Policy. This same right is also recognized under various international instruments that Moemba has ratified, including the International Covenant on Economic, Social and Cultural Rights, which I shall henceforth refer to as ICESA under Article 12, the Protocol to the African Charter on Human and People's Rights, on the rights of women in Africa, which I shall henceforth refer to as the Maputo Protocol, specifically under Article 14, Clause 2, and the Convention on the Elimination of All Forms of Discrimination Against Women, which I shall henceforth refer to as CEDAW, under Article 11 and 12. The Committee on Economic, Social and Cultural Rights noted in its General Comment 22, noted in its General Comment number 14, under paragraph 14, that the right to health includes the right to access sexual and reproductive health, which encompasses the right to access therapeutic abortion. This was the same position under the Maputo Protocol, specifically under Article 14, Clause 2C, where it provides that states must provide therapeutic abortion in instances of rape, defilement, fetal-fetal anomalies, and incest. My lords, the obligation that arises out of the right to health is to fulfill, whereby it requires states to pass laws that allow women access to therapeutic abortion. This was the same position of the Nepal Supreme Court in Lakshmi versus the government of Nepal, where it was indicated that a state has a duty to pass a comprehensive legal framework that allows women access to therapeutic abortion. In the instant case, my lords, Muemba has not passed a comprehensive legal framework that allows women access to therapeutic abortion. The only laws that exist are Article 22, Clause 2 of the Constitution and Section 152 of the Penal Code. However, these provisions are restrictive in their application as they do not include other instances that are recognized under international law where a woman can access therapeutic abortion. The respondent will argue that the right to life is subject to progressive realization, and the applicant does not dispute that fact. However, submit that despite the fact that the right to health is subject to progressive realization, the state has to meet the minimum core obligations, which is to pass laws that allow women access safe abortions. Therefore, my lords, since Muemba failed to pass laws that allow women access these abortions, and yet 8 women and young girls are dying every single day, we request this honorable court to find that Muemba violated its duty to realize the right to health and subsequently the right to life. Which brings me to my second limb of argument, that Muemba has failed to respect the right to health by criminalizing abortion. The World Health Organization, in its 2022 abortion care guidelines, noted that criminalization of abortion does not stop abortions, but rather makes the abortions unsafe. It was indicated by the CESA in its general comment number 22 on paragraph 28 that to lower the rates of maternal mortality, states have to take steps and reduce unsafe abortions. And the way to do that is by passing laws that allow women access safe abortions. In the instant case, my lords, the government of Muemba, as earlier indicated, criminalized abortion under Article 22 and Section 152 of the Penal Code, which forced women like Muyodi to now turn to unsafe abortions, which in turn has increased the maternal mortality rate. We therefore request this honorable court in regards to issue C, that it finds that the respondent failed in its obligation to pass laws that has in turn increased the maternal mortality rate in the state of Muemba. Which brings me to my fourth issue, whereby the applicant submits that Muemba failed to ensure equal access to healthcare services and education services irrespective of religious and cultural affiliations. My lords, the right to health and education are recognized under the Constitution and relevant international law, that international instruments that Muemba has ratified. They impose an obligation on the state to protect, whereby it has to take steps and ensure that third parties do not interfere with the enjoyment of these particular rights. This same obligation extends requiring states to carry out due diligence and to prevent, investigate, and punish third parties that interfere with the enjoyment of this right. My lords, when we come to the context of Muemba, as indicated under paragraph 8 of the Statement of Facts, Muemba is a secular state. However, the government has permitted religious institutions to set policies that align with their religious doctrines, and in turn, this has limited access to education and healthcare services, because these particular institutions have refused to provide healthcare services on the basis that, one, they consider sexuality education contentious and contradicts their religious doctrines, and also refuse to provide safe abortions and post-abortion emergency care, citing that it contradicts their religious doctrines. The state has also failed to put in place a legal framework that guides these particular institutions on under what circumstances they may object to provide these services, and also under what circumstances they may do so, and what resulting obligations are imposed on the state or on these particular institutions. Therefore, my lords, Since the government has failed to regulate this religious freedom, which has in turn affected citizens of Moemba, as they cannot access sexuality education and emergency abortion care and abortion-related services, we pray that this honorable court finds that Moemba violated its obligations under the Constitution and international law. I notice that my time is fast spent. However, I request this honorable court to grant me 1 minute to make the prayers for the applicant. Much obliged, my lord. In regards to the submissions raised above, the applicant prays to this honorable court to declare that this honorable court has the jurisdiction to hear this case, and the refusal of Light of Grace Medical Center to provide Muyodi with quality sexual and reproductive health care in her dire state of emergency violated her right to access self-care, and the unlawful dismissal of Pokot University based on her pregnancy and its termination violated her right to the highest attainable standard of mental and physical health, and to declare that Moemba's failure to put in place laws that allow women access therapeutic abortion was a violation of their right to health and life. And in light of the above violations, my lords, the applicant prays to this honorable court to order that Muyodi Juliana be compensated, and secondly, to order the Attorney General to make laws that allow women access therapeutic abortion, as this court has the power to order or to issue structural interdicts, and to order the Attorney General to develop guidelines for religious institutions on conscientious objections, and also for education institutions in regards of institutional autonomy. If I'm of no further indulgence to this honorable court, the applicant submits.
Thank you. Madam Eji.
Much obliged, my lord. May it please this honorable court, as earlier introduced, my name is Chitimbo Alison Faith, the Attorney General, together with the Deputy Attorney General representing the respondents. We have been allocated 20 minutes of this honorable court's time, and I shall use 10 minutes to submit on the brief facts of the matter, as well as issue 1 and 2 of the matter. My Deputy Attorney General will then proceed with issue 3, 4, and 5 of the matter. My lord, the brief facts of the matter are: the Federal Republic of Moemba is a secular country, but highly regards its cultural and religious obligations, and highly protects the right to life and health through its laws and policies that criminalize abortion and commercial sex. Muyodi Juliana terminates her pregnancy illegally and is rushed to Light of Grace Medical Center that denies her medical treatment, since the hospital would be in breach of its religious doctrines. Further, Muyodi in Pokot University, that the university she is in, her scholarship is revoked and suspended on grounds of indecent conduct and dishonoring the institution. My lord, it is therefore this application is before this honorable court. In addressing this honorable court on issue 1 of the matter, as earlier alleged by the applicants, we submit that the respondents did not violate Muyodi's right to healthcare services, because Light of Grace is a private institution. Though publicly funded, it is run with its own rules and obligations. The government cannot be held liable for the actions of the hospital simply because it went ultra vires. My lord, the government always implements policies and laws that both public and private institutions must abide by. However, if an institution goes out of these obligations through its rules and policies, and therefore tends to not provide the quality services that are supposed to be afforded to the citizens, then the hospital or the institutions itself should be held liable and not the government. My lord.
So, does that mean that the state has no obligation at all, or should not be held responsible at all in the actions of the hospital?
My lord, the
state had an obligation to implement these policies upon the institutions. And if they went ultra vires, if they did not follow the policies that were implemented by the government, then why should the government be held responsible for it? It already implemented the policies. Then I beg your pardon, my lord, if the private institution goes out of its way and does not accord the rights to the individuals, then it has therefore provided enough policies in its abdication of roles, my lord. My lord, I was addressing this issue in two limbs. As I had earlier stated, her rights to healthcare services were not violated, and the applicants alleged that her right to medical services was also violated. But my lord, pursuant to Article 22, Clause 1 of the Constitution of Muwemba provides that no person has the right to terminate the life of an unborn child. And in this matter, Muyodi wasn't in a life-threatening situation. And when she had obtained the pills and therefore wanted to complete her abortion, she went to Light of Grace Medical Center seeking for medical services. These medical services weren't for the treatment, but to complete her abortion. We cannot hold the state liable for the actions of Muyodi when she very well knew, and even if she didn't know, because ignorance of the law is not something that should be stated. But we cannot go by her ignorance of the policies.
So what is the law in this case?
The law is that abortion is criminalized in the state of Muwemba.
So in her situation, what does the state suggest? What would the state have her do at that particular moment?
My lord, the state would have her go and obtain services in a facility where religious institutions or religious affiliations aren't obligated upon hospitals, like We Care Private Hospital. Muyodi was therefore accorded the treatment she needed when she went to We Care Private Hospital. Therefore, her right to healthcare services or even medical services was not violated. She was therefore treated at the end of the day by the services offered by We Care Private Hospital.
Her issue, her problem is she had been disappointed before actually getting it right.
Yes, ma'am.
She went to the second hospital, twice a patient, if I may borrow that, than she was in the first hospital. So she didn't go to the second hospital out of choice, but to undo the damage already done.
The damage was caused by Muyodi, my lord, when she sought for these abortion services. The first hospital she went to, which was Light of Grace Medical Center, was based on religious doctrines. We cannot tell the individuals that are run privately or publicly to go against their right to religion or culture, because in religion in this state, abortion is a criminal case. They cannot help someone abort a child, yet the Constitution provides for the right to life. My lord, there are other institutions she went to and she was afforded this treatment. My lord, allow me address this honorable court on issue 2 of the matter, which provides for the unlawful dismissal of Muyodi from Pokot University based on her pregnancy and its termination, as alleged by the applicants. We submit as the respondents that Pokot University dismissed Muyodi on grounds of indecent conduct and dishonoring the institution. The fact that she tried to terminate her pregnancy poses morality grounds. If they let her stay in the institution, what else would they be showing to the other female students especially? The institution follows rules and obligations where pregnancy or termination of the pregnancy are not allowed. She was bound by these rules, my lord, as the principle is restated in the case of Sharon Dimanche versus Makerere University, Constitutional Petition number 6 of 2004, where the Supreme Court held that once an individual enters or enrolls into an institution, they are bound by their rules and obligations, their rules and regulations, my lord. Muyodi.
So, according to Council Adrian, the boy was left in school right?
Yes, my lord.
So, according to Pokot University, this girl was immoral because she went to abort, right? But she wasn't immoral for having premarital sex. Is that what you're trying to say?
My lord, we as the respondents are submitting that even as the facts are stating Davis there, we are telling the court that they do not show that he's actually the one that impregnated her. Fine, she was intoxicated and he was the one that offered that drink, but they do not clearly show that Davis is the one that actually impregnated Muyodi. Therefore, the state cannot just hold Davis accountable when they do not know that he's the one that actually did this, my lord.
So have they confirmed that she actually had this sex voluntarily?
I beg your pardon, my lord.
Has Pokot University actually had this sex voluntarily, and therefore she should be punished by the consequences? She should be punished by the consequences of having that sex voluntarily. Is that what you're trying to say? Because you're saying that what you're trying to say is that don't mind. What you're trying to say is that the gentleman she had sex with should be left to study because it has not been proved that he raped her. So the fact that it has not been proved that he raped her means she voluntarily participated in having sex and therefore getting pregnant and then desiring to abort. Are you getting my question?
Yes, my lord. And we as the respondents recognize that these institutions are given autonomy to work within their obligations, much as we have given them laws and policies that they should abide by. However, we as the state shall go into further investigations and hold the university accountable for any violations as to the right of discrimination and the highest attainable right of physical and mental health. However, my lord, the university was still working under its autonomy to make sure that its institution is not dishonored by any individual. My lord, it is therefore the respondent's prayer that this issue is taken into the negative. Allow me yield ground for the Deputy Attorney General to address this court on issue 3, 4, and 5 of the matter. I submit.
Much obliged, my lord. May it please this honorable court, for the purpose of court record, my name is Naso Vogamasi, and I pray to proceed with issue 3, which states that whether the failure of the Federal Republic of Moemba to put in place laws and policies that protect young girls and women from unsafe abortion, contributing to the high maternal mortality rate, violated their rights, violated their constitutional rights, and also the rights that are guaranteed by the international instruments. My lord, the applicants have submitted that Moemba failed to put up laws and policies that protect young girls and women from unsafe abortion. However, we as the respondents affirm that indeed the state put up clear laws and policies that protect young girls and women from unsafe abortion, and this is evident under Article 22, Clause 2 of the Constitution of Moemba, which in the first place provides that no person has a right to terminate the life of an unborn child except where authorized by law. And my lord, according to paragraph 21 of the facts, Muyodi terminated her pregnancy willingly. Why would, much obliged. My lord, according to the facts at hand, abortion is illegal in the first place, and this is evident under section 152 of the Penal Code Act, which criminalizes abortion except under certain circumstances where the life of the mother is at risk. And my lord, we as the respondents affirm that the state indeed put up clear laws and policies to safeguard the lives of women. My lord, since abortion is illegal in the first place, why would the state come up with policies that legalize abortion? And the the applicant submitted that Moemba has failed to put up that Moemba has failed its constitutional obligations by failing to legalize abortion. My Lord, it's like the applicants are simply advocating for legalized abortion. We all know that legalized abortion is against the morality of people. The state putting up clear laws and policies that legalize abortion will simply encourage other girls from doing the same, because they know that since I've gotten pregnant out of a result of rape, I'll go ahead and abort. It is really against the morality of the state.
But then your constitution states you're a secular state. So who determines the morals of your society?
I beg your pardon?
Your constitution states that you're a secular state, right?
Yes.
So the question is, who determines the morals of your society as a state?
Much obliged, my Lord. My Lord, Moemba being a secular state would wish to uphold the laws and policies that align with the interests and manifestations of the people of Moemba. And my Lord, this is evident under paragraph 8 of the facts, when the state tried to come up with an amendment proposal on the penal code to extend circumstances under which legalized abortion might be granted, and this included defilement and rape. My Lord, the same was totally rejected by a major group of people following their interfaith congregation forum. My Lord, why would the state in the first place come up with laws that don't align with the manifestations of the people? The state would wish to come up with laws that align with their choices. The state would wish to come up with laws that the people of Moemba will implement. And my Lord, we as the respondents submit that indeed the state is committed to upholding the sanctity of women and girls. And it is therefore the respondent submission that it is therefore the respondent submission that the state didn't in any way it is therefore the respondent submission that the state shouldn't be held accountable when it failed to put up laws and policies that legalize abortion, because this would be this would promote moral decay among the young people. And my Lord, I pray to proceed with issue 4, which states that whether the failure of the government of Moemba to take steps ensured at aiming equal access.
Maybe before you proceed there, the question then would be, of what benefit would morals be to a society? If your concern is, once we legalize abortion, then our society will be morally decayed. So of what relevance are morals to us if our health is really in tatters?
Much obliged, my Lord. My Lord, I would respond to that by saying that, much obliged. My Lord, the importance of morals in the society is to promote harmony. Because since the young people are the generations of tomorrow and they are not morally upright, then that means we wouldn't have a better Moemba. So since we want people to really be morally upright and we want people to be responsible, then the state can't come up with laws that legalize abortion, because it will just encourage others to practice the same, to engage in sexual practices. Therefore, my Lord, I pray to proceed with issue 4, which states that whether the failure of the Federal Republic of Moemba to put in place laws and policies that protect young women and girls from unsafe abortion, contributing to the high maternal mortality ratio, translating into 8 deaths per day, violated the rights of women and girls. My Lord, the applicant submitted that the state failed to put up the applicant submitted that state failed to ensure equal access to education and health. My Lord, we as the applicants, we submit that the state is actually guaranteeing equal access to education and health. This is evident under This is evident under Article 22, Clause 2 of the Constitution, which provides that no person has a right. Much obliged. This is evident under Article 30 of the Constitution, which provides that every person has a right to education. And my Lord, pursuant to paragraph 3 of the facts, we see that the state included education in its national budget of the year 2025-2026, where education was given 28%, showing the state's commitment to providing equal access to education. And my Lord, pursuant to paragraph 11 of the facts still, that show that the state introduced the National Framework for Sexuality Education with intentions of teaching the young girls and women about their sexuality education. My Lord, all this shows the state's commitment towards ensuring equal access to education. And my Lord, on the health services, we submit that the people equally enjoy health services without any discrimination. My Lord, according to Objective 14 and 20 of the national objectives, according to Objectives 14 and 20 of the national objectives and directive principles of state policy, require the state to ensure that all efforts are directed towards ensuring maximum social and cultural well-being of the people of Moemba, including access to healthcare services that is both physical and mental. My Lord, the respondents submit that the state has ensured equal access to healthcare services. And my Lord, currently the state is developing the reproductive health care guidelines that have provisions for emergency reproductive services. And these include the emergency abortion services that the applicants are seeking for. Therefore, my Lord, the lack of formal guidelines at the time cannot be held against the government, as they are actively working on the reforms that will be implemented soon. It is therefore the respondent's submission that this Honorable Court finds this issue in the negative. Without any further indulgences from this court, I pray to proceed with the remedies, with issue 3, which states that what are the available remedies. My Lord, pursuant to Article 128 of the Constitution of Moemba, this Honorable Court has powers to grant remedies. And my Lord, further Article...
You have an extra 30 seconds. Eh?
Much obliged. My Lord, I pray to make the general remedies in regards to the respondent's prayers. It is the respondent's submission that may this Honorable Court dismiss all the applicant's claim, since they have not in any way indicated any right that has been violated, and their application also lacks merit. I pray to submit.
Thank you. Thank you. Now we shall hear from, do you have any rejoinder? Like we agreed, you'll take 2.5, she'll take 2.5. Okay.
Much obliged, my Lord. I'll now submit in rejoinder to the respondent submissions. First, regarding to the respondent submissions on issue A, the respondent submitted that since they have passed laws, then they have fulfilled their duty. However, it is our submission that you should not only pass laws, but you should take action to prevent the violations that are occurring in the state of Moemba. My Lord, it is fortunate that Muyodi is alive today, but if Muyodi had unfortunately lost her life, would the respondent maintain those submissions? Secondly, the respondents have also submitted that abortion is criminalized and therefore Muyodi had done something that is illegal. However, Section 152 of the Penal Code Act actually allows for abortions in instances where the mother's life is at risk. And the respondent went ahead to submit that Muyodi's life was not at risk. My Lord, paragraph 22 of the facts reveals the contrary. Muyodi went to Light of Grace Medical Center and she was bleeding heavily profusely and she was cramping. My Lord, it is our submission that indeed Muyodi's life was at risk, and therefore the respondents should be held accountable. Additionally, it is also our submission that the state cannot claim that just because she went for abortion willingly, that then the state has no duty. As earlier submitted, if Muyodi had passed on, would the respondent continue to make such submissions? The law in the state of Moemba under section 52 or 152 of the Penal Code Act says that if the mother's life is at risk, then they shall be granted an abortion. It does not state that if the mother's life is at risk as a result of circumstances that she did not cause. This law does not segregate. As long as the mother's life is at risk, she can be granted an abortion, and she was not. Lastly, regarding the issue of enforcement of rules and regulations by Pokot University, the respondent submitted that Muyodi was suspended and dismissed as a result of her violation of the Code of Conduct. However, if Pokot University was true in their pursuit to promote discipline, then how comes the perpetrator, Davis, is still at university? The respondent went on to mislead the court and said that there is... Much obliged. I will now yield the floor to my co-counsel to... Thank you, thank you. The respondent has misled the court that there is no proof that Davis had indeed raped Muyodi. However, if I may read verbatim, paragraph 26, line 2 says, Davis, who had impregnated her, in brackets, in her intoxicated state. It is our submission that the facts clearly state that it is Davis who raped her and therefore should have also been dismissed. I'll now yield the floor to my co-counsel to respond to the respondent's submissions on issue 3 and issue D.
May it please this honorable court. In rebuttal, the respondent prides itself in criminalizing abortion. However, this practice by the state has killed 8 women and young girls every single day that passes by. Moreover, the SEDO Committee in General Comment number 24 under paragraph 31C provides that states must revisit criminalizing laws or provisions under their laws to allow access to safe abortions by women in their states. Additionally, the respondent submitted that Moemba passed a comprehensive legal framework that allowed women access to therapeutic abortion, and under that cited Article 22, Clause 2 of the Constitution and Section 152 of the Penal Code. However, my lords, what exists under Article 22, Clause 2 and Section 152 of the Penal Code is not a comprehensive legal framework. However, it is a restrictive framework that prevents women access safe abortions.
What would be your threshold for comprehensiveness?
Much obliged, my lord. A comprehensive legal framework would be one framework that encompasses or includes all instances that are permitted under international law, including instances of rape, defilement, fetal anomalies. So in this case, your threshold for comprehensive is non-restriction completely? No, my lord. Non-restriction is, we do recognize that the state may have a duty to put a limit on willful abortion. However, international law requires states to set up laws or to make laws that allow women access therapeutic abortion in certain instances, including when the mother's life is at risk, when there has been defilement, rape, incest, and fetal anomalies. Unwanted pregnancies? A woman has gotten pregnant and she doesn't feel she's ready. Would you advocate for that woman to keep that baby? Well, it was indicated under Park and another versus Attorney General and 3 others that women should be given the chance, or states have a duty to respect bodily autonomy, whereby it is up to the woman to decide whether they will carry the pregnancy to term or not. Much obliged, my lord. Since my time is fast spent, the applicant rests.
Thank you. I'm going to request for just a minute to tally your marks, give my remarks, and then announce the marks, okay? Okay, thank you. First of all, congratulations to you. And I would request you to clap for yourselves. Before giving my comments, I think we need to recognize that it is hard to defend government in this case. So the respondents did well. So if it were up to me, I would consider seconding you to the actual Ministry of Justice and Constitutional Affairs. Yeah. You all did well. I liked your organization. All of you were supremely organized. So thank you for the research, for the good work generally. You are so organized. I also noted that you are all measured in your presentation. It was so hard to knock you off balance. You really knew your stuff. Eh? But of course, there are some areas that I feel if we kept doing this and minding our development, we could improve and become the best of ourselves. Now, the first issue is that it is actually okay for you to appeal to the emotional faculties of the judge. After all, that is the intention of an opening statement. You gave it to me, but there was a bit of, it felt bland somehow, but you're almost there in my view. Please note, persuasion is a personal thing. What persuades one, what persuades X may not persuade Y. But I just want you to know that there is no limit to persuasion, okay? If you can appeal to the emotional faculties of the judicial officer, especially in this case, please do it. Don't feel constrained. The second issue is I felt you people were afraid of starting with your strongest points. It is important. Well, the rules of this moot may be different, but what I understand is there is no order in the presentation of your issues. The most important thing is convincing. So it is really bad for you to start with your weakest point. When you're starting to shine, you've already bumped into questions, then the time is against you, and at the end of the day, it is hard for you to convince. Okay, so it is always important for you to start with your strongest point, bias that judge, so that by the time he's trying to wake up, he's already excited. Okay, so start with your strongest point. Then when you are making oral submissions, please don't give us brief facts. You've already given them to us in your written submissions. Only do that if you're marrying a certain fact with the point you're trying to make. Relaying brief facts really wastes your time. Avoid rhetorical questions. I heard people saying, so what should government do? Should she be left to die? Personally, I call those newsroom questions. In court, we are here to answer issues. Government was supposed to do this, it did not do it, therefore it is liable for this. Okay, so avoid rhetorical questions. Of course, they are good for starting up conversations and spicing them up, but here we are submitting before court, and we need a decision from court. We don't need court to get excited by what we are saying. We want them to decide for our client. Avoid distractions. I think you know who I'm talking to. Avoid distractions. When you are making your point, unless you are interrupted, that time up is not an indicator for you to stop. Okay? For you, you just continue. You let the judge decide for himself. Okay? So once something distracts you, you are likely to get derailed. And of course, once a distraction derails you, then probably there is no originality in what you're presenting. It is possible that you are giving us cram work and you don't know what you're talking about. Okay? So when you're in your courtroom, it is you against the judge and nothing else. A ringing phone, a disturbing client, a crying baby outside, moving cars, that is none of your business. Okay? Because you're racing against time and they've already given you time to present your case. Otherwise, I feel you've done justice to this case. I know we are not allowed to give draw judgments, but if I was to make one, I would say you have both won. So congratulations. Now here are our marks. Like I said, it is hard to defend government, and probably you will see. So, on the applicant's side, Mr. Masolo Adrian, you scored 89. Miss Mirembe Linda, you scored 90. Now, for government, Miss Chitimbo Alison Faith, you scored 83. Then for Miss Nansubuga Mercy, you did well, you scored 91. Now here is our average mark. The applicants scored 89.5. Then the respondents, you scored 87. So I want to congratulate you. I wish you the best. You are going to win either here or in heaven. Court adjourned.
sit down a little bit. It's time for lunch, so we are going to release you to go and have your lunch. Lunch is just across in that garden. And when you return, please, you're going to have lunch in 30 minutes if you can. When you return, you're going to find your marks pinned up, and we shall know which teams are proceeding and which teams are knocked out, but you'll also find your marks for memorials. So have lunch first so that when we come back, we are able to proceed to the quarterfinals and the semi-final rounds later. For those who are proceeding, you'll get to know later when we are how we are going to proceed and from which room. So coordinators, kindly come to me and pick your lunch coupons. For the 2 students and the coordinator, we release those who are participating, then we can give out the coupons to those who are not participating after these ones have gone to eat. the teams that we are going to, not teams, you need to choose our sides. Let's which ones are the big ones? Katonga, Seziba, Zambezi, Sipi, Sipi, Endala Enyemerwa, Zambezi, Zambezi. Tell me one. I need one. The marks have been pinned, but as you look to see where you lie, I need the following coordinators here, and I hope they are back. CLMB, could I have the following coordinators go in front, please? CLMB, CLMF, CLMA, CLMC, CLMH, CLMG, M, and K. We don't have time, so just come in front, please. I need B, F, S, C, H, G, M, and K. If you're here and your coordinator is not here, please tell them to come. We don't have time. We have to go into the quarterfinals and we have to go into the semifinals. So I expect 8 people here. I only see 5. Who are the women though? This seems so gender imbalanced. Who are the female coordinators? I need this. Which team is that? M. M with the pen. Who is the CLMK coordinator? Or any person from CLMK, if you're a participating student? I need CLMK here. Because if they're not here, we cannot proceed with what we want to do. And as we wait for them, congratulations, guys. Like I said earlier, this is not the end. It was a competition, and I believe all of us put our best foot forward. And the marks are quite clear on that. So you should be proud of yourself. For those who have not gone through, I think for me, I would be proud of myself, because even getting to this stage really means that we can fight and we can get there. I need CLMK coordinator. I wish I knew the university name. I would shout it out, but I can't. Who CLMK? Guys, forgive me, but we can't proceed with this without them. Let me try to get them. Is there any Moota here from CLMK? Okay, so in the spirit of trying to promote fairness, I have my, I don't know if I should call them raffle draws here. So I'm just going to, pardon? Shit. CLMA, do we have CLMA representatives here? How come? I need someone from CLMA. You guys are wasting our time. I don't want them to come here and say they didn't participate in the procedure. Please reach out to someone from CLMA and CLMK coordinator. CLMA, either a Moota or a coordinator or a representative of that university. That is K. People outside, if you can hear us, we need someone from CLMA. You know what, guys, choose. They'll go with whatever they find. So I have raffle draws here, and these papers have applicant, respondent. Applicant 1, respondent 1, applicant 2, respondent 2, applicant 3, respondent 3, and applicant 4, respondent 4. If you choose applicant 1, and X chooses applicant, respondent 2, you're going to verse each other. Is that clear? Okay. CLMA will find us along the road. For those coming in, if you know you're from CLMA, please come forward. Either your coordinator or a representative. You guys should not hide the papers. You shall still get to that's CLM. It's B. Who is respondent 1? M. Okay. Who is applicant 2? This is CLM? Yes. Which one? A. And who is respondent 2? What's your team? Who is applicant 3? What's your code? C. Who has respondent G? Who has applicant 4? H. And who has applicant? It is a rough code, it's not like I You're all comfortable. Yeah, so please, the H teams that are proceeding, CLMB and CLMM, please have a session aside for 5 minutes to agree on your. No, you don't have to, it's okay. No, it's fine. It's okay. You don't have to. I forgot it's quarterfinals, not semi. So this is how we are going to proceed for the quarterfinal round. Judges are back. We are going to have CLMB versus CLMM. B are applicants, M are respondents, and they're going to proceed in Katonga Hall. We are going to have CLMA versus CLMF. A is going to be applicants, F is going to be respondents, and they're proceeding in Sezibwa Hall. Then we are going to have CLMC versus CLMG. C are going to be applicants, G are going to be respondents, and they're proceeding in CP across the pool. And finally, CLMH versus CLMK. H as applicants, K as respondents, and they're proceeding in Zambezi Hall. So kindly get there, and the judges are going to find you in the rooms. A kind reminder, you're still proceeding in the High Court of Uganda, no, of Moemba, sorry, and you're appearing before a single judge. The facts remain the same, the problem stays the same, instructions are also the same. H and K. for the clerks to pick you as the team settle. They had to focus and choose. Some of them want to.
Okay, but also the other thing. So the other two are leaving now?
No, they can't leave because they have semifinal service just.
We even have to give them certificates, but they are leaving.
They're taking the rest, they are going to be the first ones to say, okay, because they focused and agreed on who wants to be
now. Here.
Stand on your parents, yeah. So I have Jackie.
You're going to clerk.
Zambezi is a Mugwer. Zambezi is the church. Zambezi is Mugwer. It is right.
No, it's wrong. Yes, but what are those dates?
Festival is A and M. That's the second one.
No.
That is Zambezi CLMH versus CLMK. No. Yeah.
So,
then
you do have a scholarship. First, remove the scholarship in a round. No, to the quarterfinal.
No, like they were used. They were all used.
It's really punched. For yourself,
yeah,
I put here. All of us, we feared. We're like,
no, I just.
So it's CLM what? Banaba Zambezi.
CLMH versus
CLMH versus CLMK.
CLMK.
Yeah.
You can pick your judge.
Because I'm raising the issue that they appeared already.
It's knockout.
It's knockout.
But also, I need you.
Now just finish.
I need their clerks. That's Wakachonga. Pull out this one. Patricia, you're in this room. You're staying here. This one here. Yeah. You see it?
CLMB and CLMM, I think you should take your seats. B as applicants and M as respondents.
Let me put at least the name of that. It is CP, right? So why CP?
Let me show her. So there's one judge.
So you're not going across the weekend. Yeah, Patricia. This one.
No, did you change? It's the same parties. It's okay. Please wait.
Good afternoon, everyone. I'm Nangobi Miria Jackie, the judge of this afternoon.
The Federal Republic of Moemba, the High Court of Moemba at Moemba, miscellaneous clause number 1 of 2025, Aware Health Lawyers Initiative, Uyodi, Juliana versus Attorney General, and Light of Grace Medical Center.
Before you begin, forward your names for the respective groups. And usually, I want to talk to you before we begin. And that's what I have been doing. I want you to know that this is not a do or die. We are here to test our skills and knowledge, but most importantly, how you present yourselves. Because we can't be so strict on the law, but how you present yourselves. So I don't want you to be as if you're going to die the next minute. Please be calm. You're here just to present yourself and present that you have prepared for us. Allocate yourselves time, caucus, because you're co-counsel, so caucus, and get to know what time each of you has. And then also, it is very important that you accord the issues equal time so that you don't rush when it comes to the last issue that you're presenting on or that you're submitting on. Sometimes focus is lost on the last issue when you get to know that time is out and then you're rushing. At that time, your demeanor, your confidence is going because you think you're not going to submit ably on what you have prepared. So look at the issues and accord the necessary time that is needed depending on the time that each of you is allocated. Thank you.
Much obliged, Your Lordship. For purposes of court record, my name is Nansamba Jocelyn Letitia, the Attorney General of the Federal Republic of Moemba. With me, I have co-counsel, Counsel Ojambo Stephen Odemo, representing the respondent. My Lord, on the applicant side, we have Counsel Kitimbo Alison Faith and Counsel Nansu Bugamasi. My Lord, however, I'd like to raise a preliminary objection on the jurisdiction of this court to entertain this matter. My Lord, the High Court derives its jurisdiction under Article 139 of the Constitution of the Federal Republic of Moemba and under Section 14 of the Judicature Act. Clause 1 stipulates that the High Court shall, subject to the provisions of the Constitution, have unlimited original jurisdiction in all matters, and such appellate and other jurisdiction may be conferred on it.
If I may guide, you can drop the issue of the PO and proceed on other issues.
Much obliged, my Lord. My Lord, before I yield grounds for the applicants to submit, I beseech this honorable court to be guided that Moemba, the federal state of Moemba, is a developing country and it is under progress realization of human rights. My Lord, however, I understand the applicants are going to argue the right of health is violated, but my Lord, with the facts at hand, it is clear to the extent under paragraph 1 that the population is approximately 45 million people, which is a gradual increasing, tripling the population over time. With that, I yield ground for the applicants to take on their case.
Proceed.
Much obliged, my Lord. For purposes of court record, much obliged, my Lord. May it please this honorable court. For purposes of court record, my name is Chitimbo Alison Faith, together with my co-counsel, Nansubuga Masi, representing the applicants. My Lord, we have been allocated 20 minutes of this honorable court's time, and I shall use 10 minutes to address this honorable court on the brief facts of the matter, the question of jurisdiction, the issues for determination, as well as issue 1 and 2. And my co-counsel shall use the remaining 10 minutes to address this honorable court on issue 3, 4, and 5 of the matter. And we shall reserve the 5 minutes for a rejoinder. My Lord, I pray to proceed with the facts of the matter. My Lord, the federal state of Moemba is a secular country, though certain aspects of its constitution can be argued to be founded on religious and cultural inclinations, especially in the educational and health sector. Muyodi Juliana attends a campus party and is offered a drink by Davis, a senior year student. She later has no recollection of memory of leaving the party, but in clothes that are unknown to her, and Davis, the final year student, is gone. After unsettling feelings, she decides to take a pregnancy test which affirms her pregnancy. She therefore seeks for abortion services, and after obtaining them, the outcomes are painful and distressing. Muyodi is rushed to Light of Grace Medical Center, which denies her medical treatment based on the hospital's religious doctrines. Further, Pokot University revokes her scholarship and suspends Muyodi on grounds of her pregnancy and its termination, and she's therefore labeled a public disgrace, leading us to this application before this honorable court. My Lord, allow me address this honorable court on the issue of the question of jurisdiction. Jurisdiction refers to the power vested within a court to try a matter before it, and this principle is reinstated in the case of Elizabeth Chomuhanji versus Uganda, Court of Appeal Civil Appeal number 131 of 2020.
If I may interject, do you have to state that law if you want to show that this court has jurisdiction. My belief is that you have a problem question that has the law that gives this court jurisdiction. Don't you think that is the law that you're supposed to proceed under?
Yes, my lord.
Proceed.
My lord, pursuant to Article 139, vests this honorable court with unlimited jurisdiction to try all matters, together with Article 50, which provides that any claims of human rights violations can be brought before a competent court. My lord, this honorable court is properly vested with jurisdiction to hear and determine the matter before it. The applicants pray that the court finds that it has jurisdiction to hear this matter. My lord, issue 1 states whether my lord, the issues for determination are: issue 1, whether the respondent state violated Muyodi's rights when its funded facility, Light of Grace Medical Center, refused to provide Muyodi with quality sexual reproductive healthcare services in such a dire state of emergency. Issue 2 states whether the unlawful dismissal of Muyodi from Pokot University based on her pregnancy and its termination violated Muyodi's right to the highest attainable standard of physical and mental health, as well as freedom from discrimination. Issue 3 states whether the Federal Republic of Mwemba to put in place laws and policies that protect young women and girls from unsafe abortion, thereby contributing to the high maternal mortality ratio of 370 deaths per 100,000 live births, equivalent to 8 preventable deaths every single day, violated the rights of women and young girls. Issue 4 states whether the failure of the government of Mwemba to take steps aimed at ensuring equal access to education and healthcare services for all people irrespective of their religious beliefs and cultural affiliations is the violation of the Constitution of Mwemba. And issue 5 states what are the available remedies. My lord, I pray to submit on issue 1.
Be mindful of the time when you're doing your submissions on the different issues. Proceed.
My lord, as earlier stated, issue 1 provides whether the respondent state violated Muyodi's right to healthcare services when its funded facility failed to provide her with reproductive healthcare services in such a dire state of emergency. Pursuant to Article 33 of the Constitution, requires the state to protect women's rights, while objectives 14 and 20 emphasize access to physical and mental health services. Yet, as stated in paragraph 22 and 23 of the facts, Muyodi being rushed to Light of Grace Medical Center was denied treatment and was labeled as sinner, and therefore the services offered were counseling and prayers, yet she was in such a dire state of emergency. My lord, we recognize that Light of Grace Medical Center is a religious-based institution. However, the religious doctrines should not infringe on the rights of individuals. As stated under Article 20, Clause 2 of the Constitution of Mwemba, it makes it clear that the state must protect citizens from such discriminatory policies which cannot override constitutional rights. And together with Article 2 of the Constitution also provides that it declares it the supreme law, and therefore any other law that is inconsistent with it, to the extent of its inconsistency, shall be declared null and void. This is in line with the Light of Grace Medical Center's rules and regulations that fail to provide Muyodi with healthcare services in such a dire state of emergency. This was a violation of her right to life, dignity, and health. My lord, further, in Article 14 of the Maputo Protocol provides for the rights of women, and these rights include access to maternal health care services, which Muyodi wasn't afforded. This principle is further reinstated in the case for Center for Health, Human Rights and Development versus Attorney General, Constitutional Petition number 16 of 2011, where the court affirmed that failure to provide adequate maternal health care violates women's rights. Denying Muyodi urgent care stated in paragraph 22 and 23 of the fact is in line with this violation, my lord, and it is therefore the applicant's submission that this issue is found in the affirmative.
My Lord, I will now address this Honorable Court on issue 2, which states whether the unlawful dismissal of Muyodi from Pokot University violated her right to the highest attainable standard of physical and mental health, as well as freedom from discrimination. My Lord, I will address this Honorable Court on this issue with 2 distinct claims, and the first one being violation of Muyodi's right to the highest attainable standard of physical and mental health. This right is compounded under Article 12 of the International Covenant on Economic, Social and Cultural Rights, as well as Objectives 14 and 20 of the Constitution, which provide that healthcare covers not only physical care but social and mental well-being, which Muyodi was first denied at Light of Grace Medical Center and Pokot University, which the sole basis of her dismissal wasn't on grounds of academic reason or indiscipline, but on grounds on the fact that she was trying to access her healthcare services in such a dire state of emergency. My Lord, punishing Muyodi for seeking treatment undermines her very right to access healthcare services, as well as the right to the highest attainable standard of physical and mental health. This caused trauma to Muyodi, emotionally and socially, showing that the state, through its institutions, violated her rights. Allow me to address this Honorable Court on the second claim, which is the violation of her right to freedom from discrimination. Freedom from discrimination is provided for under Article 21, Clause 3, which means treating people differently based on their sex, religion, or race. And it also provides for equal protection under the law in all spheres of life, read together with Article 2, which obliges states to uphold the rights of individuals. As seen under paragraph 25 of the facts, my Lord, Pokot University dismissed Muyodi and made her face sanction, yet Davis, the final year student, wasn't afforded this kind of sanction. He was made to continue his studies while Muyodi had to be suspended and her scholarship revoked.
If I may, was any information about Davis brought to the attention of the university, and by who? Proceed.
My Lord, the fact that the university... My Lord, I see that my time is up. I pray for 1 extra minute to complete my issue.
The 1 minute is given.
Much obliged, my Lord. My Lord, the university, and according to the facts, they already provide that Davis was the one that was mentioned. The university, if it really wanted to provide equal rights for all, they would have looked into the whole situation and afforded Muyodi the audience she needed and ascertained that it was actually Davis who was mentioned in the facts that actually impregnated her, and he too should have been accorded the same sanction. My Lord, this was blatant gender discrimination, and she was therefore labeled a public disgrace, and professors and students bullying her. This is another way her violation was compounded. My Lord, much as Pokot University could be sued in its own capacity, the state remains the #1 guarantor and protector of human rights, as stated under Article 20 of the Constitution of Muemba. My Lord, it is therefore the applicant's prayer that this issue is taken in the affirmative. I now yield ground for my co-counsel to address this Honorable Court on issue 3, 4, and 5 of the matter. Much obliged.
Much obliged, my Lord. May it please this Honorable Court, for the purpose of court record, my name is Naso Bogamase, representing the applicants, and I pray to proceed with issue 3, which states that whether the Federal Republic of Moemba's failure to enact and implement laws and policies that protect young girls and women from unsafe abortions, contributing to the high maternal mortality rates, violated its constitutional and international human rights obligations.
Maybe for the issue of time, your co-counsel has already laid down the issues. So unless you're going to tackle them differently, if they're going to be tackled in the same arrangement, you can just proceed on issue number 3.
Much obliged. My Lord, the applicant submit that the state violated its constitutional and international obligations by failing to put up clear laws and policies that protect young women and girls from unsafe abortions. And my Lord, the absence of such laws has led to the country's alarming high maternal mortality rate, which contributed to 370 deaths. My Lord, the absence of the same laws has equally contributed to the harm that is suffered by Moyodi. My Lord, according to the facts at hand, Moyodi went to Light of Grace Medical Center seeking for medical attention, yet the medical center refused to grant the same to an extent of her womb being evacuated. My Lord, had the state put up clear laws and policies under which it lays down certain circumstances where girls are allowed to abort, then Moyodi couldn't have faced such unfair circumstances. And my Lord, according to Article 16, Clause 1, Paragraph E of the Convention on the Elimination of All Forms Against Discrimination, according to Article 16, Clause 1, Paragraph E of the Convention on the Elimination of All Forms of Discrimination Against Women, guarantees that women have a right to decide on the number of children, and they also have a right to decide on the space given, to decide on the spacing of their children. My Lord, the applicant submit that this right necessarily includes the right to access to safe and legal reproductive health care services. And furthermore, my Lord, pursuant to Article 16, Clause 2 of the Maputo Protocol requires the state to authorize medical abortion in cases of sexual assault, rape, defilement, or where the life of the mother is at risk. And my Lord, according to the facts at hand, Moyodi went to Light of Grace Medical Center seeking for the post-abortion services. She actually went to Light of Grace Medical Center after bleeding. So when Light of Grace Medical Center refused to grant her the same, she was left in a dire state. She was left in an unfortunate state whereby her womb was also evacuated. My Lord, we as the applicant submit that such denial inflicts physical and psychological suffering, especially where the circumstances involve vulnerability. It is therefore the applicant's prayer that may this honorable court find this issue in the affirmative. My Lord, issue 4, allow me to proceed with issue 4. My Lord, the applicant submit that the state has violated its constitutional and international obligations by failing to guarantee equal access to education and healthcare services free from religious and cultural discrimination. My Lord, this is evident under the facts where in the government's handling of the National Framework for Sexuality Education. And my Lord, according to paragraph 11 of the facts, the National Framework for Sexuality Education was introduced in 2016, yet by 2024, only 9 out of the states had implemented the same in their primary and secondary syllabus. My Lord, the applicant submit that the state has permitted this selective adoption without any binding enforcements or measures. My Lord,
if I may, did you look at the effect of ratification of these international conventions? And can you submit also on that?
Much obliged, my Lord. My Lord, according to the General Comment number 14 of 2000, states that the state must regulate and ensure that all health services, whether publicly or privately run, but publicly funded, are accessible and in good quality, are accessible to all people without discrimination. And my Lord, Light of Grace Medical Center refusing to give Muyodi the urgent care that she needed on grounds of its religious affiliations violated her right to health as guaranteed under Objective 14 and Objective 20 of the National Objectives and Principal Guidelines, much obliged, as guaranteed by the National Objectives and Directive Principles of State Policy. And my Lord, in regards to education, the government of Mwemba violated the women's rights in regards to education. My Lord, education is guaranteed under Article 30 of the Constitution, which provides that everyone has a right to education. The mere fact that Pokot University dismissed Muyodi on grounds of her pregnancy and her termination violated, because these can't be valid grounds as to why a woman or a girl should be expelled from school. And on top of that, my Lord, the Pokot University, a fully government-funded facility or a publicly owned facility which belongs to the government, revoked her scholarship and also dismissed her. Yet Davis, a final year student who was equally involved in the same act, was left to continue with his education. This, my Lord, depicts gender-based discrimination inconsistent with the articles that guarantee equal treatment of all people in Mwemba. It is therefore the applicant's prayer that may this honorable court find this issue in the affirmative and hold the government liable for their failure to guarantee equal access to education and healthcare services irrespective of one's religious and cultural affiliations. And my Lord, I pray to proceed with issue 5, which are the available remedies. And pursuant to Article 126 Clause 2 and Section...
Use 2 minutes.
Yes.
Okay.
Pursuant to Article 162 Clause 2 and Section 9 of the Judicature Act provides that this honorable court has powers to grant remedies. It is therefore on that background that the applicants are seeking for the following declarations. Much obliged, my Lord, the applicants are seeking for a declaration. The applicants are seeking for a declaration that the refusal by Light of Grace Medical Center, a fully funded government facility, to provide quality sexual and reproductive health care services to Muyodi in such a dire state of emergency violated her constitutional and her international obligations. A declaration that the unlawful dismissal of Muyodi from Pokot University, a government-owned institution, on the basis of her pregnancy and her termination violated her right as to the highest standard of physical and mental health. A declaration that the failure of the government of Mwemba to put up clear laws and policies that guarantee women from unsafe abortions violated their constitutional guaranteed rights. And my Lord, it is therefore on that basis that we as the applicants are seeking for general damages of 100,000 millions on the basis that Muyodi went through, on the basis that Muyodi's, it is on that basis, therefore, that we as the applicants are seeking for 100 millions as general damages, because Muyodi went through a traumatizing moment to the extent that her womb was evacuated. Therefore, the applicants pray that may this honorable court find the above stated declarations and also award us general damages. I pray to submit.
You can have a seat. I'm going to make my comments at the end of the submissions to allow you submit peacefully. I'll make my comments after. So you can proceed, the respondent.
Much obliged, my lord. For purposes of court record, my name is Nansamba Jocelyn Letitia, the Attorney General of the Federal Republic of Moemba. My lord, the Federal Republic of Moemba is a constitutional democracy in East Africa, in East Central Africa, and it has a population of approximately 45 million as provided in paragraph 1 of the facts. My lord, Moemba is a state that is subscribing to progressive realization of human rights. Simply means that the state continuously works for realization of the social, economic, and cultural rights over the time using the maximum available resources. My lord, we cannot put aside the fact that only 5% is allocated to the health sector in Moemba, but however, even that 5% is equally productive to some extent because we are seeing a population of 45 million people. Thus, my lord, at least Moemba as a state, it is on steady progress and we shall get there. My lord, I'm dealing with issue 2 and issue 3 of our submission. If it may please this honorable court, I beg to proceed.
Proceed.
Issue 2 states that whether the right to access health care services and essential life living commodities guaranteed by the Constitution of Moemba, particularly to the refusal of Light of Grace Medical Center to provide Moyodi, that is the second applicant, with quality sexual and reproductive health care services in such a dire state of emergency violates her right to life. Before I proceed, I beg this honorable court to be guided that I'm going to use 12 minutes of its honorable time. My lord, I cannot continue delving into this issue minus this honorable court understanding what health is. In the case of Brooks versus Canada, it is a 2015 case. The Supreme Court of Canada went ahead to agree with the definition of the World Health Organization Constitution as it is defined to mean the state of complete physical, mental, social well-being, and not merely absence of disease or infirmity. My lord, in the same line, the Black's Law Dictionary is clear to the health is a state of being sound or wholly in body, mind, or soul. In other words, it is the absence of pain or sickness. My lord, since we are dealing with sexual and reproductive health care as part of the major points.
If I may guide, if you're submitting on a principle, I'm just guiding you that don't quote so many cases which are speaking to the same thing. It is a wastage of time.
Much obliged. My lord, sexual health is a state of physical, emotional, mental, and social well-being in relation to sexuality. Furthermore, reproductive health is a state of complete physical, mental, emotional, and social well-being in all matters related to the reproductive system and its functions, whereas the processes. My lord, Article 20 of the Constitution of Moemba provides that the fundamental rights and freedoms of individuals are inherent and not granted by the state. We contend that there was no direct violation of any right, as the hospital's actions did not directly violate the second applicant's constitutional rights as outlined under Article 45 of the same Constitution, which states that rights, duties, declarations, and guarantees relating to the fundamental rights and other human rights are freedoms especially mentioned in this chapter, that is chapter 4, shall not be regarded as excluding others, not specifically mentioned. My Lord, the religious freedom is a fundamental right and it is protected by both the domestic and international laws, as Moemba is party to under Article 60 of its constitution. My Lord, Article 29, Clause 1c of the Constitution guarantees the right to freedom of thought, conscience, and religion. Now, this includes the manifestation of one's religion in practice. Examples of religious institutions include hospitals with religious affiliation. And as the second respondent, they argue that providing sexual and reproductive health, such as contraception and abortion, affects or violates their moral and religious beliefs. My Lord, Article 18 of the ICEPR, which Moemba is party to, defines religious autonomy and conscious objection, where religious institutions and healthcare providers may invoke contentious objections as legitimate reasons to refuse providing services that they believe are against their moral objections. My Lord, in Iwelder and others versus the United Kingdom, the court acknowledged that religious freedom includes the right to practice one's beliefs even in a working environment. Though the context differed from health services, the principle of balancing individual and institutional rights with public obligation comes to play. My Lord, a question is raised, a question of pluralism and diversity of health providers. The argument here is prioritizing the right to health over religious beliefs or the right to religion. My Lord, in a pluralistic society, multiple health service providers include secular and religious institutions, and both of them institutions often cater for specific populations. Thus, in this regard, with the facts at hand, Light of Grace Medical Center, religiously affiliated hospital, contend that patients should seek in other places that do not have their same morals or religious obligations. As stated under paragraph 1 of the facts, the Federal Republic of Mwenda is secular. My Lord, as I proceed, in Duggan and Wood versus Greater Glass and Clyde Health Board, the UK court ruled that midwives...
If I may, do the religious beliefs override the supreme law?
Much obliged, my Lord. Any Article 2 of the Constitution is clear to the extent any law that is inconsistent with the grand norm is null and void. However, my Lord, Article 45 are bound to respect public health. Those religious institutions might have a greater latitude when their moral identity is at stake. My Lord, under Article 18 of the ICCPR, it emphasizes that the freedom to practice one's religion can only be restricted under specific conditions. My Lord, as the second respondent, we argue that there's no imminent public health crisis that would justify overriding their religious beliefs, especially if alternative services are available. Like prescribed in the facts, it is a secular state, thus there are secular hospitals that could deal with her. And basing on the fact that she had already had an intention of aborting and she had already gone through the process, my Lord, let us imagine if the process had gone on successfully, would she have come to Light of Grace Medical Center? Obviously not. My Lord, Article 43, Clause 1 provides, in the enjoyment of the rights and freedoms prescribed in the chapter, no one shall prejudice the fundamental or other human rights and freedoms of others or the public interest. My Lord, it is on this basis that the hospital was only, that it is on this basis that I submit that the hospital was equally in practice of its right to religion. We pray this issue is found in the negative. Much obliged. If it pleases this honorable court, I pray, I beg to yield ground for co-counsel to submit on issues C and D.
Much obliged. May it please the court. For record, my name is Ojambo Stephen Odemo, appearing for the respondents, and I'll be submitting before this honorable court within 2 issues, and my first issue deals with whether the dismissal of the second applicant, Muyodi, is against the law, and I will start by saying that we are dealing with a right which is not absolute. 3, it is subjected to limitations. Your Lordship, Article 21 guarantees right and freedom from discrimination to the extent that any person must be treated equally before and before the law. However, Clause 3 defines what discrimination is as giving different treatment to 2 or more different people. Your Lordship, in the matter before this honorable court, we are seeing only the second applicant, the decision being taken against the second applicant. So, where is another person whom the rights of the second applicant being discriminated against? Your Lordship, in the case of Sharon Dimanchi and others versus Macquarie University Constitutional Petition number 2 of 2004, the Constitutional Court stated that each institution like Macquarie University, of course, which is a university in Uganda, has gotten policies, rules and regulations, whereby for someone to join such an institution must have subscribed to the policies. That's our point. We stand to submit before this honorable court that the second applicant, having joined Pokot University, must have read all the rules and regulations of the same and must have subscribed. Therefore, the actions which were taken against her were not discriminatory. However, she failed to play her contractual rights, whereby she was supposed to behave, she was supposed to keep herself as per the rules and regulations of Pokot University. Going on, the second limb of the argument is right to education. The Lordship right to education is provided under Article 30 of the Constitution. It's also not absolute. In the same case of Sharon Dimanchi and others versus Macquarie University, they raised an argument that they were being discriminated relying on their religion. And the Constitutional Court stated that it was not discrimination because this was a smaller group of the Seventh-day Adventists who wanted to be treated in a special way, being that they had sessions on Saturdays. Your Lordship, the matter before this honorable court, the applicants are alleging that the right to education of the second applicant were violated. However, we aver that this right is not absolute. It is subjected to the rules and regulations of the second respondent. Therefore, it's our prayer that this honorable court finds the actions of the second respondent not violating the rights of the second applicant. However, they are in line with its policies, rules, and regulations. Going on to the last issue, Your Lordship, we are dealing with the issue of violation of right to life, whereby the applicants argue that the failure of the state to ensure safe and legal termination of pregnancy violates the plaintiff's constitutional right. There is nowhere in the Constitution of the Republic of Mwemba that abortion is legalized. Article 22, Clause 2 is the effect that no person has a right to unlawfully terminate the unborn child. It is supported by Section 152 of the Penal Code, which criminalizes any termination of the unborn child, whereby
it can only be done when it can only be done within certain circumstances. For example, when the pregnant mother's life is at stake. Refer to the facts at hand. The life of Muodi was not at stake. She formed up a pre-mind to go and terminate the baby. Her actions against the Constitution and against the Penal Code Act. Your Lordship, in the case of...
If I may ask, if she made a resolution to go and abort and terminate the life of a baby, does that mean that her life was not at risk to debar her from getting medical services from the facility?
Your Lordship, the question of lawful abortion comes into play when the circumstances which are provided under the law are met. For example, if the pregnancy is a risk to the health of the mother. In the case at hand before this honorable court, the pregnancy was not causing any risk or any danger. That means her termination of pregnancy was just malafide. She just made up that mind to go and terminate. In the case of Sharon Dimanchi, in the case of Susan Kigula rather, and 417 others versus the Attorney General. This is a case of Uganda Constitutional Petition number 6 of 2006. The Constitutional Court stated that right to life being that it's among the rights which are not granted by the state. It must be respected, it must be upheld, and it must be protected with all agencies and all persons. Your Lordship, the second applicant terminated the life of the unborn child. Assuming we're all in this room aborted, it would be a disgrace to this nation. Your Lordship.
Seriously, no. We are not going to assume that we all aborted. No.
That's why it is an assumption.
Proceed.
Your Lordship, it's therefore our submission that this honorable court protects the law, the Constitution, and all international instruments. In ratifying international instruments, this state reserved Article 14 of the Maputo Protocol, which legalizes abortion. It's therefore our prayer that the alleged actions against the first and the second respondents are not unconstitutional and do not in any way violate the right of the second applicant. And also, we pray that may this honorable court dismiss this application with each party bearing its own costs. Much obliged.
Before you take the seat, I wanted clarity from you. Because someone was terminating a pregnancy, does it deprive them from the right to the services that they're supposed to have?
Much obliged, your Lordship. We believe that international instruments provide right to autonomy of anyone's or person's body. However, in our domestic laws, right to termination of pregnancy is still criminalized. Therefore, if you have a right to terminate pregnancy, and we also have a right to safeguard, we also have a right to safeguard the life of the unborn child whom we have terminated. It is the mandate of the state to protect the life of the unborn child. The Penal Code Act under Section 152 is clear to the extent that no person will or no person shall terminate the right of the life of the unborn child. Therefore, in the case of anyone tampers the life of the unborn child, the state comes in because it is a crime per se. Much obliged. I beg to submit.
Thank you. Any rejoinder from the applicant?
Much obliged, my lord. The first respondent alleged that the religious freedom is a fundamental right, and this therefore means and implies that therefore it is absolute. However, Article 44 of the Constitution provides for the non-derogable rights, and the freedom of religion is not among them. This means that it can be limited, and per the instant case, where Muyodi's life was in a life-threatening situation, the right to religion should have been limited in order for Muyodi to access her reproductive health care rights. I yield ground for my co-counsel to submit more on the rejoinder.
Much obliged, my lord. My lord, the respondent submitted that the hospital's actions did not violate Moyode's rights. However, we as the applicant submit that once a private entity performs public functions with state's funding, it assumes constitutional obligations to uphold human rights. And my lord, according to the case of Chamanywa versus Inspector General of Police, Constitutional Petition number 46 of 2011, the Constitutional Court held that private actors exercising public duties are bound by the rights and obligations as stated under Article 20 of the Constitution of Moemba, which makes rights binding to all citizens of Moemba. And furthermore, my lord, we as the applicants are not seeking for legalized abortion. We are simply seeking for clear laws where a person might be allowed to terminate the pregnancy. My lord, if we look at the instant case, Moyodi was just raped under her intoxicated state by Davis. The respondents are trying to say that if a person was simply raped, then they should keep the pregnancy. However, we as the applicant submit that the state should be held liable for the actions of Light of Grace Medical Center, because we as the applicants or the state of Moemba, we need clear exceptions under which a person is allowed to carry out legalized abortion, like rape, defilement, or where the mother's right is at risk. And lastly, my lord, the first respondent submitted on the 5% allocation, the 5% national budget allocation on the medical sector. My lord, when we look at the facts, paragraph 3 of the facts, the state went ahead and allocated 32% on the defense and the national security. I think the state could have, my lord, in my submission, the state could have allocated an equal share on the security and also health, because it is a core human rights. It's a core human right.
Maybe to guide you when you're doing your rejoinder generally. Okay, submit. I'll guide later. Proceed.
Much obliged, my lord. I pray to submit.
Let's clap for our people here. I just want to thank the two teams for the good work done. Like I said, we are not here to fault you on the law. We are here to see that the skills that you acquire from your different universities can be seen in these presentations. The applicants, you submitted well. You can clap for yourselves. The respondents, you also submitted well. You can clap for yourselves. The applicants, when you're doing your what you called prayers, I don't want to go to the previous, sessions, because I'm believing that when you're doing the previous sessions, you were guided or you were taken through. My first concern in those previous sessions was that you people had no pleadings. I don't know whether that was told to you. You had no pleadings. And when you have no pleadings, there's no basis for submissions. Because the question would be, where did you get your submissions if you had no pleading? They gave you facts from which we're supposed to extract pleadings and file them, and then get submissions out of those pleadings. 2, the applicants, when a question arises of this nature, the expectation in your prayers, 1, is that after you asking for declarations, in court there's something that we call giving orders in vain. There are orders that court gives and you cannot execute them. You have them, You move with them everywhere, but they are as good as not having them. For example, if you go ahead and give declarations as court and end there, the question is, then what? And that is, I think, the question that I've been asking. Then what? After court declaring that you see there were these violations, then what? You're asking for damages, which is not a bad thing. Damages can be awarded. But after damages being awarded, then what? The applicants, the first person who submitted that they wanted damages of 100 million, but also went ahead and stated that they wanted also declaration that these violations were made by the respondents, which is not bad. But usually when you ask for declarations, also ask for orders out of those declarations. And I think the hosts of this Moot are good at that. That in the cases that they have had, and I believe this is where they get this interest from, in the cases they have had, they have gone ahead to also ask from courts what you may call structural interdicts. And what do? When they ask for these structural interdicts, the court is supposed to give orders as to the declarations so that we ensure that there is submission, so that we ensure that these orders that court has given, they have, they're not issued in vain. For example, if you're saying that the state, like she submitted, that they want the policies to come out clearly, the question is, who do you want court to order to implement these policies? It should come out. And these are the structural interdicts that I'm talking about. You ask for them specifically, and then ask that a timeline is given so that there's a follow-up on these structural interdicts, whether they have been followed. For example, if a policy is going to be put in place, which institution exactly do you want court to pass this order against? And when court passes this order, then you also have to make sure that there's a follow-up on these orders so that you ensure that they are put in place. Otherwise, when you ask for declarations, plain declarations will leave you with nothing in your hands, because declarations do not give you a remedy. Declarations only declare that this is yours. Then what? Maybe someone is seated on your land and someone is saying that we declare that you're rightful owner of this land. Then what? If someone is seated on that land, you need an order to evict them. So same applies to this. If you have something that you want, like a policy, then you go under the structural interdicts. So they are very necessary when you're doing this. For the respondents, you did well also, but at some point I had you saying that, actually I had you conceding that you as government, you're not doing so well, but you promised to do well. And I was asking myself, is this an admission to some of the facts so that we enter judgment in admission? So usually when you're on the other side, you also be particular and specific on what you're replying to. Otherwise it may turn into an admission. The other side may stand up and say, we ask for judgment in admission because you have admitted to some facts. But that said, that said and done, I commend you for the good work done. These are good teams, and yes, I'm impressed for the work well done. Then the other thing before I go off, for the applicants, there's something that I wanted to ask. There's a way you are avoiding Article 60. And my question was from the beginning that this was a problem question with its own facts. if you're migrating from this problem question to assimilate it to Uganda, be specific and let us know that this applies in this way. But when you were talking about jurisdiction, you went out of that constitution, because Article 60 is the one that was giving original jurisdiction to the High Court to try the matter that you're proceeding in. So usually when you're doing this problem question, you don't, if you're moving out, then you have to explain. You don't just abandon and then move to something else. But that said and done, I'm impressed. Thank you so much. I'm going to give you a few minutes, and then I compile the results, and then they will be communicated. Hello. Court is in session again. These are the results. There was Team B and Team M. For Team B, who are the applicants? They performed as follows. Chitimbo Allison got 83%. Nansubuga Mercy 76%, which totaled to 79.5. Team M, that is the respondents, Nansamba Jocelyn 87%, Ujiambo Stephen 84%, which resulted in 85.5%. Those are the results.
Hello, everyone. Well done to those who have been engaged in the quarterfinal. We are going to proceed to the next and final for one team, two teams that are still yet to come. So we cannot announce any result unless they are here. Just give us a few minutes. Please bear with us.
Hello, good evening, everyone. So I know the situation, the environment may now be tense, but I also want to remind you that we have a market. Like you were earlier informed, we have a market where we are selling very good products at affordable prices. So you can please be a part of the Center for Health, Human Rights and Development in advocating for the rights of young women and girls by supporting our market. We sell umbrellas, t-shirts, bags, and many other things at affordable prices, by the way, so you can reach out at the back and get yourself anything that you feel you may want.
Hello, everyone. It's me again. The team you were waiting for, we finally gotten the results. And I'm sure the judges read back to you the marks that you got, right? So I'm just going to emphasize why, because we need the coordinators here. I'll just mention that I'm not the one tallying the marks. We have our tally center person behind there, but she's not feeling so well to come here, so I'm just stepping in to re-emphasize this. So we had 4 teams we had 8 teams for the quarterfinal. We had CLMB and CLMM who were in this hall, Katonga. We had A and F in Sezibwa. We had C and G in Sipi. And we had H and K in Zambezi. So for the team that was here, CLMB and CLMM, CLMB got 79.5% and CLMM got 85.5%, which definitely means that CLMM knocked out CLMB, and we are going to have CLMM proceeding for the semi-final. Then for the teams that were in Sezibwa, we had CLMA versus CLMF. CLMA got 84% as a team average, and CLMF got 89.5%, and CLMF is the team that is proceeding to the semi-final. Then for the teams that were in CP, we had CLMC versus CLMG. CLMC got 79%, CLMG got 80.5%. So CLMG is proceeding. While for the teams that were in Zambezi, we had CLMH versus CLMK. CLMH got 68.5%, while CLMK got 75%. So we are going to have CLMK proceeding. So could I kindly request the coordinators of M, F, G, and K to come and choose their next sides for the semi-final. Just for emphasis, you're now going to the appeals court, or the Court of Appeal of Moemba, and you're appearing before a panel of 3 judges. So please, that's how we are proceeding. And just for emphasis, we are still going to go with the 1-hour rule. So kindly try to maintain the rules of time and instructions. Could I have these coordinators here, please? We don't have time. M, F, G, and K. CLMM. Where is M? Where is F? Where is G? CLMG, any coordinator or any student who is here? CLMG. time. CLMG, I need a the coordinator or one of the participating students. That's the team that was in CP, I think. I don't know if they've already come this side. We talked about timekeeping, and somehow we are not keeping time, which is unfair to some of the teams. The clerk is already back. I think they left the team in the room. Maybe they're still focusing or something. But I know that the judge and the clerk are back, so maybe the team is still. And we cannot proceed with this because we need them to be here to also choose a side. So they are going to pick papers. You pick a paper, and the papers have appellant 1, respondent 1, appellant 2, respondent 2. If you pick appellant 1, you're going to appear with respondent 1. And if you pick appellant 2, you're going to appear as an appellant, and you're going to verse respondent 2 on the second panel. The first panel, if you pick 1, you're going to proceed in this room. And the second panel is going to proceed in Sezibwa. As you can see, our judges have gone to the rooms. And like I mentioned earlier, a judge should never have to wait for you, even in practice. You have to appear in court before the judge. So we are still waiting for CLMG to make their way here. Are you CLMG? Okay. So, Sarah for draw. Yeah, so we are good to go. We are going to have CLMK versus CLMG. That's the first. CLMK, your appellants, CLMG are responding. Please go and guide your team to go to their rooms. Well, for the second panel is CLMM as appellants versus CLMF as respondents. So kindly, every team coordinator, make sure your team goes to their panel or to their room and prepares to proceed. Oh, just a reminder before you go, CLMK and CLMG, we have given you 5 minutes to caucus and agree on your issues. Okay. CLM, M and F, do the same. Please caucus and agree on your issues in few minutes.
should I notify you? 512, still the same venue. 4.
Put your appellant. Appellant, yes.
Your appellant,
Yeah.
you'll write Hi again, children.
We have 20 minutes, right? I'm going to use 7 minutes.
You're the first?
Yeah, I'm the first.
You're the first responder?
Yes.
Then how after that should I notify you of the time?
You should notify me when I'm having 3 minutes time. Maybe
time.
1.
Okay, 3 and 1.
Yeah.
Then how?
He's going to use, I'm using 7. That means he's using 13.
Then after that, when should I notify you?
At 5 and 3.
Would you write your name?
Yeah, two, please. 2 here.
Okay, and keep
Time they're going to cut out your arguments. If you don't keep time, they're going to cut you out.
Yeah, so how is working?
Hey, go. Looking. Oh, nice. You can sit.
Yes.
All rise. The Federal Republic of Moemba, Court of Appeal of Moemba at Moemba, miscellaneous application number 1 of 2025, Aweri Health Lawyers Initiative, Muyodi Juliana as the applicants, and the Versing Attorney General and Light of Grace Medical Center.
Okay, congratulations to all of you. May the best one win. We are not going to lay down the ground rules. The presumption is that we all know them. So what we are going to have is you informally giving us your names and the teams you're representing. Then we start, okay? Thank you. Where are the applicants? Okay. Sorry. The appellants. Yes, okay. So you're going to tell us your names. Who's presenting first? Is it you? Okay.
Lord Justices, good evening to you all. My name is Alinda Lord, the Attorney General of the Federal Republic of Moemba. Alinda is the Deputy.
Alinda?
Lord.
Lord.
Lord, L-O-R-I.
Oh. Okay. Alinda Lord. Okay.
And with me is the Deputy Attorney General, Pinyorea Brenda.
I beg your pardon?
Pinyorea Brenda.
Okay. Could you kindly spell it? Okay. Okay, Brenda. Okay. Which team is it? Okay. Don't worry, this is informally for just for us to get your details. The time is not running yet. Okay. CLMA. K. Sorry. Okay. Okay. Respondents. The one presenting first. Is it you? Okay. Which team is this? Okay. The name? Kamukama. Kamukama Susan. Okay. Yes, sir. Your name? Marvin Ainebiona. All right. So we can now start.
Lord Justices, good evening once again. As I introduced, my name is Alina Lord, the Attorney General of the Federal Republic of Moemba. The facts giving rise to the current case appeal is on the fact that Muyodi Juliana, the first respondent, being aware of disastrous effects of unlawful abortions as cautioned by the state in the newspaper, went on, procured an unsafe abortion. However, she experienced complications. She went on to the second respondent hospital. She came to the first appellant hospital where she procured, she was denied. Where she was denied access to post-abortion services on grounds of institutional constraints and public morality. However, the respondents went to the High Court of Moemba alleging that such a limitation on rights was a breach of the first respondent's right to access health care, as well as that her dismissal from Pokoti University premised on her violation of the institutional rules constituted as well as the right of freedom from discrimination and highest standard of attainable physical and mental health. On this ground, the High Court of Moemba ruled in favor of the applicants, and this gives rise to the current appeal on three main grounds. One, whether the land trial judge erred in law in holding that the High Court had jurisdiction to entertain the submission presented by the respondents. Second, as whether the land trial judge erred in law and fact in holding that Pokoti University was entitled to reinstate Muyodi. And finally, this court is called upon to adjudge on whether the land trial judge erred in law and fact when they interrogated political question matters than restraining himself on matters of human rights violations when the order to finalize and pass. With this in mind, I turn to our first issue, which relates to the jurisdiction. And indeed, it is the appellant's submission that the case before this court, that there was a material error in law by the trial judge of the High Court in holding that the questions presented before him were a matter of human rights enforcement. We acknowledge that pursuant to Article 50 of the Constitution, a person who claims that a fundamental right has been violated can apply to a competent court. Article 50 does not establish what amount a competent court of jurisdiction. On this ground, we submit that may this court be persuaded to find that indeed the court lacked jurisdiction within the meaning of Article Article 50, Clause 1 of the Constitution, and with therefore allude that the case fell within the constitutional interpretation under the jurisdiction of the Constitutional Court pursuant to Article 137, Clause 3 of the Constitution, as the questions presented before this court alluded to the whether or not the dismissal of the first applicant was consistent with equality principles, as well as whether or not the denial of access to health care by Light of Grace Hospital constituted a breach of Article 2, Clause 2, which provided that where a policy or any custom by private or government agencies breach the Constitution, it amount to question of constitutional interpretation. And on this basis, we submit that indeed, as heard in Tinyefuza versus Attorney General, the Supreme Court Constitutional Appeal number 2 of 2002, the Supreme Court of Muwemba cautioned that not every question which raises matters of human rights enforcement are fit to be enforced under Article 50. However, to preempt the defense, they may argue that within the meaning of Article 126, Clause 2, in particular paragraph E, the court was endowed to entertain the case without due regard to technicalities. However, we submit to the contrary. In Rwanyarare and in Rwanyarare, court held that indeed where technicalities must be proved that they were not of a substantial effect to be followed, and Article 126, Clause 2, in particular paragraph E, was not intended to allow litigants disregard principles of litigation. And on this basis, indeed, we submit that there was a material error in law and fact by the land trial judge of the High Court in holding that the court had jurisdiction. If this court has no any question for me, I turn our second issue of appeal on whether or not there was a violation, on whether or not the trial judge erred in law and fact in holding that indeed Pokot University had violated Muyodi's right to education, freedom from discrimination, as well as the right to highest standard of physical and mental health. And on this regard, we submit, one, that Light of Grace as well as Pokot University enjoy the right to freedom of institutional autonomy. Second, that the limitation fell within the permissible scope of human rights under Article 43 of the Constitution. And lastly, that in any case, there was no any mandate or constitutional right to abortion by the first applicant. Therefore, we submit that this falls within the permissible limitations on fundamental rights within the meaning of Article 43 of the Constitution. With this in mind, I turn to substantiate on our first point of consideration on the right to education. We acknowledge that pursuant to Article 30 of the Constitution, read together with Article 26 of the Universal Declaration on Human and People's Rights, as well as Article 17 of the African Charter on Human and People's Rights, the first respondent was entitled to enjoyment of such right to education. And I understand that the Land Council for the respondents had relied on Article 12 of the International Convention on Economic, Social, and Cultural Rights, which mandate that states should ensure the provision of education rights as it is indispensable in realization of any other fundamental rights. However, may this court seek guidance from the case of Okero versus Makerere University, where court emphasized that any disciplinary measure taken in action for breach of misconduct cannot amount to the violation of the right to education. And in this regard, we submit that pursuant to paragraph 26 of the facts on record, Muyodi's dismissal was not solely premised on her pregnancy, but also violating and misconduct, as well as dishonoring the institution. On this regard, we submit that there was no such a violation on her right to education. Turning to our second submission on the right of freedom from discrimination, we submit that indeed, pursuant to Article 21 of the Constitution, as well as international treaties of which we consider that, like the Maputo Protocol and the Schedule, of which we consider that pursuant to Article 60 of the Constitution of Moemba, we have duly ratified. We submit in this regard that there was no such a violation. And this was emphasized. May this court seek guidance from the case of Panton versus Pregnancy Advisory Trustee, where court emphasized that not every differentiation amount to an unlawful discrimination. And in this regard, we submit that what amounts to an unlawful discrimination is whether or not the question was based on prohibited grounds or it was proportional to any objective pursued in this regard. Pursuant to paragraph 8 of the facts on record, we submit that the limitation was proportional as it ensured protection of public morality, and pursuant to paragraph 22 of the facts on record, we submit that indeed there was a need to counterbalance rights and protect the right of an unborn. We acknowledge the vulnerability of the first respondent at that state. However, we want this court to avert itself and look at the vulnerability of the unborn child at the same state. And indeed, we submit both of them were at stake. And secondly, if Muyo had come before this court seeking that indeed she was denied proper abortion services, this was a question of contributory negligence, and therefore all the harm that she suffered from cannot fulfill the affirmative action which the respondents may argue pursuant to Article 33 of the Constitution, and therefore the limitation fell within the permissible scope of limitation on fundamental rights. And may this court be persuaded by the case of Joyce Nakachwa versus the Attorney General and others, Constitutional Petition number 2 of 2000 court, where the petitioner alluded that there was a violation of her right from freedom of discrimination when the health center dismissed her while still breathing in maternal pain. And in this regard, we submit that this is the same question presented before this court. The court today is faced with a hard task of balancing two competing rights. And on this regard, we submit that there was no such a violation as the dismissal was premised on lawful grounds. And with this court's permission, I turn to my last point of consideration on right of highest have failed to demonstrate that the dismissal, my Lord Justices.
30 seconds for you to conclude.
Much obliged. The respondents have failed to prove that the effects suffered by the applicant were a result of Pokoti University's action, and therefore we submit that Pokoti University had no ground of providing health care services, nor did it obstruct Grace Hospital from providing any emergency post-abortion services, and therefore there lacks a link between the two rights, and may these two be dismissed with costs. Therefore, with this court's permission, I cede the floor to my land colleague address this court.
Maybe before you sit, what do you want to be dismissed with costs?
Much obliged. I will retract my statement. That was a material and a slip of the tongue. On this basis, we submit that may this court be pleased to allow this appeal and find that there was a material error by the trial judge of the High Court. And with this court's permission, I cede the floor to my land colleague to address this court on issue 3 and make the prayers for the appellants. I thank this court for its time. Much obliged, Lord Justices.
Much obliged. Lord Justices, for purposes of record, as earlier on introduced, my name is Pinoloya Brenda. I'll be using 8 minutes to respond to issue 3 and make our prayers. My Lord, Lord Justices, proceeding to issue 3, the appellants submit that legislative autonomy and national sovereignty lies within the state. Moemba, as a sovereign nation, retains the right to regulate healthcare policy in accordance with its cultural, moral, and religious norms. That discretion whether or not to legalize abortion lies within the competence of Parliament. My Lord Justices, that the decision whether or not to legalize abortion lies within the competence of Parliament and not courts. Courts must respect the separation of powers and avoid compelling legislative demands, reforms in matters involving cultural, moral, and religious sensitivity. Lord Justices, I beg this court to adopt the decision in Sehad versus Attorney General, where although Ugandan Constitutional Court recognized the agency in maternal mortality, it refused to mandate legislative amendments in regards to Ugandan health laws, reiterating that abortion policy matters are best left to the elected representatives. And Lord Justices, given the Mwemba's cultural and religious landscape, abortion policies must be determined by democratic processes. And besides, there is no binding obligation to legalize abortion. Although Mwemba is a signatory to the international instruments, including schedule and the International Convention on Economic, Social, and Cultural Rights, these instruments do not impose a binding obligation to legalize abortion. The state retains the discretion to implement these obligations in line with its moral and legal framework. Lord Justices, Article 43 of Mwemba permits reasonable limitations on rights in the interest of public safety and morality of unborn life is a state legitimate interest, and any restriction on abortion squarely falls within that permissible limitations. Lord Justices, the state's obligation in respect to reproductive health is progressive and not absolute. Article 45 of Mwemba's Constitution and Article 12 of the International Convention on Economic, Social, and Cultural Rights recognize the rights to the highest attainable standard of health. However, Article 2, Clause 1 of the International Convention on Economic, Social, and Cultural Rights, Mwemba must take steps to progressively realize socio-economic rights. And my Lord Justices, in the government of Republic of South Africa versus Grootboom, the South African Constitution noted that states are not obligated to immediately fulfill socio-economic rights, but rather to put in place reasonable measures to achieve these goals. And pursuant to paragraph 3 of our facts, Muemba has allocated 5% of its budget to health. And moving forward, the government has gone ahead to advertise, pursuant to paragraph 20 of our facts, on a newspaper, warning young women and girls to avoid dangerous merchants that come luring them into unsafe methods with devastating consequences. However, the respondent, Muyadi Juliana, went ahead and procured unsafe drugs from unauthorized network, administered it without any prescription outside the healthcare framework. Therefore, the government cannot be blamed for private and unlawful conduct omitted outside the legal framework. Lord Justices, it is the appellant's submission that no causal link exists between the state policies and the alleged injury suffered by the applicant. The applicant's injury arose from self-administering drugs obtained from unlawful network. And secondly, pursuant to paragraph 23, when Muyadi was turned back from light of grace, she, instead of rushing to an alternative, she went back home and slept, went back the next day to seek for this help. That led to her developing hypovolemic shock and uterine sepsis, leading to all the consequences that she suffered. Had she taken immediate action, this could have been avoided. Lord Justices, the appellants submit that the government of Muemba has not violated its constitutional obligations, and it is taking reasonable measures to progressively improve maternal health. Abortion restrictions are lawful. It is upon this argument that the appellants pray that this honorable court order that there was no violation of the applicant's constitutional and internal rights, and the respondent's right to education was not violated, and that the government satisfies its obligation to promote access for all. I beg to submit.
Thank you. May we hear from the respondents?
Much obliged, my lord. Your lordships, if it may please this honorable court, for purposes of record, I'm Kamkama Susan, as earlier introduced by the Attorney General, appearing for and on behalf of the respondents, and I'm going to be responding to issue 1 and issue 3. I'm going to use 13 minutes of this honorable court's time, and my co-counsel is going to use 7 minutes. Without wasting more time, I will dive into replying to the first applicant, who averred that on issue 1, which states whether the land trial judge had in law when he held that the High Court has jurisdiction to handle this issue. Your lordships, I don't agree to this, and I argue that the land trial judge had jurisdiction to hear the case. human right enforcement and not a case of constitutional interpretation. And I will dive into Article 50, Clause 1 and Clause 2 of the Constitution of the Republic of Moemba, which authorize any person who feels like their rights or rights of others have been infringed, have a right to apply to a court of competent jurisdiction for redress. I will further bring the knowledge of this Honorable Court to Section 3 and Section 4 of the Human Rights Enforcement Act, which also provide that any person or organization whose rights have been infringed can apply to court for redress, and that the court shall hear any case on the enforcement of human rights. And it is on these grounds, Your Lordships, that I submit that the land trial judge had the jurisdiction to hear the case. I will go ahead to persuade this Honorable Court with a case of enforcement of patients and health workers' rights limited versus Karunji and others, where it was held that the High Court possesses unlimited original jurisdiction to hear all civil and criminal matters, including matters of enforcement of human rights. Your Lordships, I do not concur with the submissions of the first applicant, who averred that the High Court did not have the jurisdiction, and I therefore submit that the High Court, according to my submissions, had jurisdiction to hear the matter. Furthermore, in the case of Ismail Serugo versus Kampala City Council and another Constitutional Appeal number 2 of 1998, Wambuzi CJ held that the Constitutional Court to have jurisdiction, the petition must show on the face of it that the interpretation of the Constitution is required. And according to the facts before this Honorable Court, on the face of it, there is nothing that shows that this matter needs constitutional interpretation, but rather it...
Counsel, which jurisdiction is being challenged?
The jurisdiction of the High Court.
And the decision you've read is discussing which jurisdiction?
It is discussing the jurisdiction of constitutional appeal, of the appeal court.
Now theirs is the High Court, not the Court of Appeal, the Constitutional Court, which you are actually appearing before. You seem to suggest that they have raised a PO challenging this court's jurisdiction, which in and of itself would be strange, considering they are applicants. You get my point?
Yes.
Okay.
Much obliged, my lord. I do not say that they raised the PO, but my submission was about them suggesting that the High Court had no jurisdiction to hear this case, and hence applying to this court for appeal. Furthermore, I will respond to issue 3, where issue 3, which states whether the land trial judge had in law when held that Pokot University had no justifiable reason to expel Juliana and order her reinstatement. Your Lordships, I do not still agree to the submissions of my land colleagues on the applicant side, because surely the Pokot University has had several reasons to suspend
Muyodi and also revoke her scholarship. Your Lordships, when Your Lordships, according to the facts before this court, it under paragraph D, that the facts state that the court, that Pokot University suspended Muyodi Julian on grounds of indecent conduct. But my lord, being pregnant is not an indecent conduct, and in the case of Center for Health, in the case of Legal and Human Rights Center and Center for Reproductive Rights on behalf of Tanzanian girls versus Tanzania, in the year of 2023, it was held that the ban prohibiting pregnant girls from attending school in Tanzania was not only misinformed, but also led to the violation of a particular key human right. Your Lordships, according to the submissions of the respondents, I aver that Pokot University did not really have any reason to suspend Muyodi Julian, and her being pregnant does not amount to violation, is not an indecent conduct, and their actions actually violated Muyodi Juliana's rights to education, as clearly stated in the case I read previously. Article 22 of the Constitution provides for the Article 30 of the Constitution provides for the right to education, and Article 26 of the Universal Declaration of Human Rights also affirms the right to education. Your Lordships, the actions of Pokot University suspending Muyodi from the university actually violated her rights, and her rights under Article 30 of the Constitution and Article 26 of the Universal Declaration of Human Rights. Your Lordship, I'll go ahead to discuss on the point of discrimination. Article 21 of the Constitution provides for the right to equality and freedom from discrimination. Your Lordships, Muyodi Julian was at university. However, the person who got her pregnant, who is called Davis, was left to continue with his studies, and to a very bad note, to my surprise, and it's like Davis is looking forward to do his final examinations, which is discrimination based on gender, and thus I submit that Pokot University had no reason to suspend Muyodi Julian, but instead to uphold her constitutional right to the highest attainable education services. In conclusion, I pray that this honorable court upholds the decisions of made in the High Court, and find the case in of the respondents. I beg to submit.
Maybe before you leave, so after determining in favor of the respondents, what should we do with this appeal?
The appeal should be dismissed.
Okay, thank you.
Much obliged.
Counsel.
Much obliged, my lord. For purposes of court record, my name is Marvin Ainibiona, and I'm representing the respondents in this matter. I am simply going to handle issue 2. For purposes of clarity as well, I am going to use 7 minutes of this court's time. My lord, issue 2 really clearly states that whether the land trial judge, add in law, when he interrogated the political question matters than restraining himself on matters of restraint and violation of individual rights. My Lord, I beg to persuade this honorable court with a very recent decision that was made in the case of Innocent Ngobi Ndiko versus the Attorney General and another constitutional petition number 23 of 2020. My Lord, in this case, the lead judge quoted Article 126, which clearly cites that for judicial power to be exercised, it is in accordance with the norms, values, and aspirations of the people, and at the same time, it must be exercised in reference to the law itself. My Lord, in this matter, as the respondents, we feel the land trial judge in this case was right to determine the same. Because what is provided for in Article 126 then looks at the aspirations of the people. My Lord, if you are to look at the facts at hand, the amendment proposal 2021 was neglected following strong opposition from religious affiliations. My Lord, it is very clear that once government has failed to put out its obligation as much as enacting laws is concerned, as provided for by Article 79 of the Constitution of Moemba, which clearly states that the legislature has an active role to enact laws and policies that guide the state in its operation. My Lord, it is clear that regarding such a simple analysis, the land trial judge had all the rights to administer the political question as addressed in the appellant's submission. The appellants simply claim that this was a political question. A political question is where a court refrains itself to determine an issue because of its political nature. My justices, it is also clear that the question in determination...
Who said what you have just said?
Pardon?
That definition of the political question, what is your authority?
My Lord, I'm simply giving a comprehensive understanding on what a political question looks like.
So it is your view.
My Lord, for purposes of court, we are looking at the reference of how a political question then looks like.
Okay, proceed.
My Lord, it is very clear that the appellants claim that this looks like a political question, and not to waste further time for court. This is very open, and it is actually a simple discussion that shows that this did not exist as a political question, but it was something that court was making an order on, so as to ensure that the citizens of Moemba attain the highest standard of health and education in that regard. My Lord, I beg to submit, unless there are further questions.
Okay, thank you. Rejoinder, and I hope you're both going to present your rejoinder. So you have 5 minutes. You should split them evenly for each of you to be assessed. So it is 2.5 minutes for you, and then the same for her. Okay.
Lord Justices, good evening once again. Within 5 minutes of this court's time, I will make 3 points in rebut of the submissions presented before. by the respondents. Starting with the question of jurisdiction, we submit that the land council for the respondents alluded to the case of Ismail Sergo versus Kampala State Council and another constitutional petition number 2 of 1998. However, in the same ruling, the Supreme Court cautioned that not every question presented as a constitutional right qualifies for enforcement under Article 50 of the Constitution, as well as Section 4, subsection 1 of the Human Rights Enforcement Act. And in this regard, we submit that the questions presented by the respondents before this, that were presented by the respondents before the High Court, were more of constitutional matters. One, that they looked at the legality of the policies at Pokot University in regards to its code of conduct, as well as the provisions of the hospital in light with Article 2, Clause 2. And therefore, it is on this basis we submit that the land judge erred in law in finding that the case before the High Court was admissible. Much obliged.
Okay. You're done? Okay.
I was still submitting.
Okay, in just 2 seconds.
Okay. Therefore, in this regard, we submit that the trial judge erred in law and incorrectly applied the harmonization of the conflict rule, which asserts that fundamental rights should be intertwined with each other and should therefore be held in accordance with limitations under the Constitution. And regarding the right of discrimination, may this court be persuaded by the case of AB versus University of Cape Town. Lord Justices.
Okay, it is understood.
Okay.
So that you can give her to also respond. Maybe she could start with that point.
Much obliged, my lords. The Cape Town, the case of AB versus University of Cape Town, where court recognized that separate disciplinary processes may occur without violating equality principles. My lords, the principle, my lords, I feel that the points have been exhausted and I don't have much to say.
Okay, thank you. Thank you. Thank you very much. I think we should clap for them. Yes. So we are going to take off a minute to tally the results. Then we shall give you our feedback and then announce to you the final results. Okay? So, thank you so much. Your results are ready, but we have just a few comments for you before we tell you the final results. So, the first one, of course, is the obvious one. There was no eye contact at all. At least he tried. We did not feel it. Then your arguments did not flow so well, so we failed to make out what the introduction was. What were you concluding? Basically, what did you want? So it was quite hard for us to pick out what grounds you're actually defending, what did you want, the remedies you are looking for. Then, like we have always emphasized, when you're doing your oral submissions, please save yourself the trouble of giving the full citation unless you have two cases of similar parties. There you may give citations. Then I feel some of you were using punchlines. That is what I could call them. Words like, if this court has no questions for me, I want to sit, or I leave it to my friend, to my if I'm of no further indulgence. That is too mechanical. It is quite hard for someone to know whether you actually mean what you are saying. So please reduce, if not eliminate those punchlines. Then please avoid sounding robotic and coached. Some of you, that is what you really sounded. It was really hard to put your name next to what you are saying. So there is a confidence issue on that. Then the authorities you are citing, some of the authorities you are citing were high court authorities, yet you are appearing before the Court of Appeal or the Constitutional Court. So I don't know whether you wanted the Constitutional Court to to be bound by the High Court decisions. So please mind that. Then avoid throwing phrases just like that. Highest attainable level, you leave it there. We don't know where it came from. We don't know why you have brought it. We don't know the relevance. Some of these phrases sound fancy, but if it has no context to it, then it becomes quite useless. Then legal jargon, I've realized some of you are finding it hard to use legal jargon in court. If you're countering the opposite counsel's submission, you just say, "I do not agree." I do not agree. That is quite disturbing. So you need to work on your jargon, and because that is going to be your trade as a professional, as a lawyer. Then your body language. Some of you, your body language was not giving, right? It was, like I said, it was really hard to believe whether you actually believed what you were saying. There was too much reading, so it was quite wanting there. Then it is also important for you to deeply research on the grounds of appeal. I feel that was lacking, because one of the biggest grounds of appeal that seemed to come out was the political question doctrine. I expected you to deeply tell us what it means, who said it. That's why I asked you for the authority, and I was quite surprised that it didn't come, but next time better. Then the appellants seemed to only represent the Attorney General and forgot that there were two appellants. So the second appellant's appeal was not defended at all. So it may as well be dismissed for non-appearance. Also, when we are in the Court of Appeal, we deal with, at the appellate court, we deal with issues, we deal with grounds, not issues. Most of you seemed to be dealing with issues, which is quite strange. You also did not know, you didn't give us the question for interpretation, the question before this court. We did not know what question was presented by the appellants. The remedies sought, it didn't come out. What remedies were you seeking? I think he asked this court to dismiss this appeal, and yet he was the applicant. So you need to familiarize yourself with what you want before this court. So on a whole, please manage your panic buttons. All of you are panicking. I don't know why. You need to manage your panic buttons, otherwise you will get disappointed. Okay? So, without any further ado, these are our marks. We are going to give you the average. Each of us, of course, graded you, and then we came up with the average. So we are going to give you the final average. So CLMK, on average, scored 72.33333. Then CLMG scored 75.16. Thank you so much for your time. And case I court adjourned, I think.
Hi everyone. How are we feeling? Our dear students, how are you feeling? May I request those who are outside to kindly come in? How are you guys feeling? Are you very cold? Are you tired? Are you exhausted? Are you... How are you feeling? Exhausted? Sorry, don't worry, we are done for that day. Okay? Those who are outside, please come in. So, mine is simple, very simple. I think it's just to welcome back the teams that have been taking part in the semi-final and to give all of you a round of applause or kudos for the commitment, for the passion, for the zeal, for the will you have shown, and for the fight that you have all put up. We really appreciate you for that. The marks have been read, but again, just for emphasis, we had CLMK versus CLMG in this hall before a bench or a pan of 3, and CLMK on average got 72.33, and CLMG on average got 75.16. And like we told you, semi-finals are for knockout. That means CLMG has knocked out CLMK. While for the second panel, which happened in Teziwa Hall, it was CLMM versus CLMF. CLMM got an average of 72%. CLMF got an average of 73.5%. And that means CLMF has knocked out CLMM. So I'm going to request the coordinators of CLM, G, and F to come and do our usual rituals to know who is going to proceed as an appellant and who is going to proceed as a respondent tomorrow for the final round. And once that is done, we are going to take about maybe 5-6 minutes. We are going to recognize and award the best memorials and the second best memorial. The marks are there. I'm sure they already know themselves. And then after, we are also going to recognize our judges for the day because tomorrow they won't be with us. And I promise after that, I'm going to let you guys go and rest. Yeah? Yeah. But as CLMF and G, where are they? I need the coordinators. Where is the coordinator of CLMG? CLMF? Do we have any students from CLMF here? Amidst the numerous calls of timekeeping and not wasting time, I feel like coordinators today, some, not all, have not been fair to us. So I need either the coordinator of CLMF or a motor of CLMF to come. If they do not come here, CLMG is going to choose a side, and whatever side is going to be for CLMF. I think that will be fair because you are wasting time, which we shouldn't be wasting. So for tomorrow's round, the final round, CLMG is the appellant, CLMF is the respondent. Thank you very much. Should we give him a chance to pick again? Oh, it's done. But what's fair? Should we give him a chance to pick again, or we call it a... Because you see, I called the coordinators to come and pick, and he was nowhere. Okay, I'd say how do you prioritize fairness, but please, I hope this is a last warning to coordinators that when we communicate something, please take it serious. I'm going to request Truth to help me do this again. When she's done, they will come and pick again. But this is the last time coordinators should do this, because it's not fair that others were here and you wasted their time, with all due respect. Yeah, we shall do that again. First, go back. So I'm going to invite Ms. Nachibu Kanur to come and take us through the next session as we await to do this. In the meantime, CLM G and F, I hope you can get some time to agree on your grounds for tomorrow.
We must be exhausted, aren't we? But the day has ended. Can we clap for ourselves? We started off by saying people should not faint. For those that appeared before the judges, I'm sure you can stand here and address people. Tell them that you're confident. Those that said, for us we shall do your research and sit in the background, you will forever, never, ever have the confidence to stand before people to speak. So, I'm very certain that by now, we know who is appearing before the judges tomorrow. I want to assure you that we have secured judges from... Do you have constitutional court? Yes. We have secured judges from the Constitutional Court, from the Supreme Court, and the High Court. And I'm certain by now I have the names of the judges, but you will see them tomorrow. Our experience has been that the judges reach here at 9 and the students are not here. This year we almost said we are not paying for any student to sleep in the hotel, because what's the purpose of paying when you can't be here when the judges are here? It's a cost wasted in my view. Therefore, for us to be able to continue paying, I think we all need to pay for the motors. We expect the motors and the coordinators to be here before the judges. It's very unfair for these judges to go to their courts, collect themselves to come here. We place them in a VIP room to dress up, to prepare for court. They get to here, then you guys run out to take tea. If we continue doing this, the next year we shall not pay for the hotel. We'll save that cost for another Moot. If we have to be sleeping here, the rest come from home and it's okay. But motors have got to be in court before the judges. Otherwise, you miss out on a skill of time management. The judges cannot wait for you. The reason we delayed today is partly because you delayed. It is 6 and we are still here. But the beauty is we are still fresh, excited and happy. And that is important in life. So please, even if you spend the night awake, because they also question, why do you pay for us when we spend the night putting documents together? Will you walk back to your homes after? At least you freshen up, right? So please, even if you're going to spend a sleepless night, because I know people are going to agree on issues, I hear grounds of appeal and all that, please be here on time. It is also a skill in litigating. Okay? Otherwise, if you don't, you'll get to court at 9:30 and they will tell you the court has been dismissed. The case has been dismissed and your counsel coming to appear before the judge. What will you do? And it is possible. So I want to request you to kindly be here, not at 9, at 8. If people have to take tea, they have to take it before the judges come in. Please. We are going to start on time because they have requested us that by 1, they'll be walking out. So if we start by 9:30, it means that they cannot exceed up to 1:30. They have specifically requested, and I will emphasize, that they will leave this place at 1. What that means is that they have finished your business with you and that they have also finished having lunch. And that they have also finished awarding you by 1. Are we together? Okay, having done that, I really wish to appreciate I want to appreciate all of you for again taking time, first to apply, to share those pleadings, appreciate the judges for looking at your submissions and pleadings and marking you and giving us the best universities that we are having today as those that had the best memorial. It will be very unfair of me to award you when the judges that gave us these lists are here with us. So I'm going to request that the judges join us to award you. Our dear judges, you gave us the best memorial. You also gave us the second best memorial. So it is fair that you join us to award them. Are we ready? Do you want to hear this? Okay. So please know that this is not coming out of today. This is coming out of the pleadings that you made. So, to our dear judges, you gave us the best memorial as who? As which university? I will say the name of the university because this is what is presented here. And this is Islamic University in Uganda, female campus. Ah, you guys are not happy. Banang. Well done. Female campus. It's okay. And take your time to take the photo because you'll never get it anyway. So I'll do some bit of organizing so that they really get the photo. Maybe you stand somewhere here. I hear diagram. Okay, so please receive. Why aren't we clapping? You think it's easy to put these things together? Okay. Where are the smiles? Good. So we take time on these things because we want to put on our statuses, right? So the same justices gave us the second best memorial. Who do you think it is? Yours. It's yours. So they gave us the second best memorial as King Caesar University. So why aren't we clapping? Please take your time and smile. You can stand here, take your time and smile. It is your day. All right, so congratulations to all of us, but that doesn't mean that the rest did not perform. Those that have been watching the football happening in the country, which football is that? Chan, you also know that even the host was kicked out, right? Even when we wanted to be the what? The winners. So there will always be a winner in everything. For me, it is the effort that you put in to put the pleadings together. The person who sat down and drafted from an application has not remained the same. So we are all winners, right? So having said that, the rest of the people will be awarded tomorrow by the judges, depending on how you present yourself before the judges, okay? However, our judges have also done well in terms of preparing us, guiding us, supporting us, marking our memorials, giving us who is the best and who is not. So I'll take the honor to award them. And Esther, do you want to read the names?
Okay. Yeah. We are going to start with Her Worship Nangobi Miria Jackie. Next is Her Worship Kambeda Lydia. Then we are going to award His Worship Wegoe Joel. Then His Worship Mugweri Ambrose. His Worship Busulwa Ivan. Her Worship Wiwo Fatuma Rashid. And finally, Her Worship Ariokot Esther Joyce.
So thank you so much. Allow me to take the honor to appreciate the judges for the day. And the judges today are coming from different magistrate areas. Some are coming as far as Kapchora. Others are coming as far as Iganga. So please appreciate them for having been here with us today. I know that we are tired and we have tomorrow to do several things, but allow me appreciate the lecturers that are here with you. Those that have lecturers, please appreciate them, but also allow me to appreciate those lecturers that did not travel with you, but sat with you day and night to put things together. Perhaps they could not make it today, but I'm very certain they did well to prepare you. And to our motors, you guys did a good job. So I am going to request that the motors take a photo with the judges, because we noticed that we take on the second day and we never take these photos for day one. So the motors, whoever appeared before a judge, I am going to request that the judges come back for a photo with the motors. Motors, please. The people that appeared before the judges were the motors. Can you please come? Aish, you move like snails. Whew. You guys move. You're never going to get this moment to take photos with your judges. I am creating content for you, and you don't want to take the opportunity. Our dear judges, kindly allow to take a photo with our motors. I am not sure if you want to take. Are you sure the judges are not going to stand up? So we have so many students. I would kindly request that the judges. Okay. Okay. So I am also a multitasker. I can do some of these things. So we're going to request the judges to sit. In the meantime, the coordinators are going to prepare. Okay. For you, you clap and say next year I am the one mooting. You want the photo moment? You really want? Okay. For us, we are this side because what did we do anyway? Are we okay, camera person? Okay. Some people are too behind though. I hope they can be seen. Where are the smiles? But this time you should be smiling, Vanangi. Yes. Smile, Ko. Some people are saying, please smile. You'll get angry later.
Say cheese.
Okay. Thank you. So I am going to request that the judges remain seated, and I'm not sure about the names of the universities, but it is fair that we do the universities.
We have IU Mbale. Is the
Okay.
coordinator here?
Let the students come if the coordinators are not here, but let the students just come and take their photo.
Yeah, we have IU Mbale.
Please, when your name is ready, you come. If you're not ready, you tell us you're not ready. Are you Mbale? Not here? Female campus?
They're there. No, Mbale.
Mbale?
is there.
Auntie, when people don't come, we shall go to our next and you'll miss that chance. It's 6:34 and people fear traffic jam. Now you move like women. Women don't move slowly. They move fast.
Yes, the same university.
So shall we have both IU people here? So that
IU
both
Mbale,
universities are here?
Females campus and Kampala campus.
Kampala and female, can you be here? Where are your coordinators? You have the coordinators with you. Can't smile. Smile for the what? For the picture. Next, please.
Makerere.
Makerere University, where are we? Not here? Not
Bishop
here?
Stewart.
Stewart? But are we sure all Makerere University students are not here, even those ones that are sleeping here?
I don't know why
We shall recall. Bambi, when you come, you smile. We are not here to be gloomy. We are here to smile. I'm a lady. That one. Great. Another university.
Uganda Pentecostal Kampala. And
Please
Fort
come
Portal.
with your coordinators.
Uganda Pentecostal University, Kampala and Fort Portal.
This team needs to be awarded. Eh? Yes. There's something in this team.
Cavendish.
You guys, have you smiled? Some people are looking at me. Smile.
Yes. Cavendish, yeah, you're next after them.
Where are the smiles? This one was a Mano team. Perfect. Cavendish.
Cavendish, and then after Cavendish, we have Nkumba University.
Please make sure you smile. When you appear in that link we are going to share and you're not smiling, blame yourself. We've given you time. Okay.
Kumba University.
Kumba.
As King Caesar prepares.
Where are the smiles? Very. Okay.
King Caesar University.
King Caesar.
As Metropolitan International University prepares.
Okay, can I have all the clerks, the people who clerked for the
Yeah.
judges? Where are we? Metropolitan, Tenaba? Okay, okay. Where are the smiles? Banange.
Metropolitan, are you here? Do we have KIU in the house? Is KIU here? If KIU is not there and...
The Mooters? The smiles are for you.
IUEA, are you here? Seems like all these guys have left. IUEA is here. So we don't have Metropolitan and KIU and Makerere. I think they've gone somewhere too.
Where are the smiles? Good. Metropolitan, as the clerks prepare, and I'm going to request that the staff...
Do we have Gulu University? Okay. Let the clerks come.
Are the universities done?
The rest are not here. Gulu, Makerere, Metropolitan, KIU.
Okay, okay. All right, shall we have the clerks, please? Oh, Gulu is here. Perfect.
Is here, okay.
Please smile for the picture. We can't afford to have traveled all the way and then we don't smile for a photo.
Kampala International University.
KIU, are we here? KIU, are we here? No?
KIU, Makerere, and Metropolitan.
Okay, shall we have the motors? Sorry, the clerks. The people that clerked. As the coordinators for the different universities prepare. Push, push, and smile. You're not going to be clerking for the judges. The judges are smiling and you guys are not smiling. So shall we have the coordinators as the SEHAD team prepares? Coordinators.
Coordinators.
Why aren't you clapping for coordinators? Coordinators and lecturers.
It's your time to shine.
Who has not appeared in the picture? Who has not taken a photo? No one. Okay. Our coordinators and lecturers that supported us, why aren't you clapping for them? Yeah. Hey, we are going to kindly request that you smile. Please smile. As they clap, we shall clap. Who are we to refuse? And can we have the staff to take a photo with the judges? Colleagues, come. The team behind the preparations. Florence, Judith, Faith, Jackie, Shakira, Immaculate, Chivuka. Please hurry. Ruth, Esther. You guys, we can't be moving like snails, yeah? The judges are tired, and you need this photo with them. Okay. So these guys are the ones behind the moat. My role was just to speak the English, but they did everything. Yeah? They were the ones in the kitchen cooking. So you should be clapping for them. And we are going to give the best smiles As always, yeah? Yes. Accept that you're gifted. Okay, unfortunately, I can't call the service providers to take their own photo, but we really appreciate you. Thank you so much, our dear judges, for that day. We're going to kindly request that you step back. I am going to hand over to Esther, but I want to really, really appreciate you for today and ask you to be as composed and calm for tomorrow as possible. Okay? Remember, I said your social capital starts here. If you move out without anyone's contact, you'll forever be like that. Then you say, oh, I was part of the Moot. Then they say, who do you know? None. So I want to appreciate you so much for now and call upon those that still want to see Sehad and celebrate Sehad to please go to the website and register for the upcoming conference, which is next week, 3rd to 5th. Part of that will be celebrating 15 years of Sehad. You want to see this happen. You have a special payment for the students, which is just $100. The rest are paying $250. Students are paying $100. So utilize that opportunity. Come celebrate with us next week at Mestil. See you then. I hope you'll be able to recognize me after the makeup.
Yeah, we are done, by the way. I'm not here to stress you again. I think for me, mine are just 3 communications. Thank you for today, by the way. Thank you for the resilience. Thank you for being here with us. And for those who are not here, even if I'd communicated for them to be here, it's too bad. So one, I know that many of you slept here, and I'd communicated that we would give you an allowance for your dinner. I hope you guys ate yesterday. Some of you might be here when you didn't eat. Please, I told you to eat. We shall give you back your money. So as soon as we are done, we are going to have a list behind there. All the residents, that is the 2 motors and the coordinator, kindly pass by and we give you your dinner allowance for yesterday and today, so that you do not blame the hunger strike on us. Yeah, that's 1. 2, please and please be in the room tomorrow. And this goes especially to the 2 teams that are going to the final. Please, it is very rude, it is very uncouth for the judge to come in the room and you're not here. It has ever happened before. So if you know you're a finalist, please make sure by latest 8:30 you're in this room. And even if you're not a finalist, please let's respect the mood and come in here, because it's not good for the judges to also come to an empty room. Okay? So it's just a kind request. If you please make sure you rest early so that you can be able to be here on time. Have your breakfast on time. Don't go for breakfast at 9 a.m. when we have started. Don't go for breakfast at 9:30 when we have started. It's very disrespectful. So it's a kind request from Sehad, from us. Please, let's all be here on time. Once we start on time, we shall be able to finish on time. And even if you're not participating, I'm sure there is a thing or two that you will learn from that Supreme Court judge, from that Court of Appeal judge, from that High Court judge. And it's a very interesting bench. I'm sure you won't want to miss it. So come and see what happens here. And then I had 3 communications. I think I'm also tired. Yeah, if you have any query regarding your accommodation here, please reach out to me. I'm very available. You can either give me a call or you can find me where I am, and I'll be able to support you. Other than that, thank you for today, and please go and have a restful night. The 2 teams should come and pick again. As I give a final warning to coordinators not to do this again. It is very bad, it's bad manners to respect the rules of the game. Yeah. That is G. This is F. So it's going to be F as appellants and G as respondents. The clock has turned. Yeah, that's it, guys. Please pass by and get your dinner and reach out to me in case of anything. I've set you free. Please go, and I'll see you tomorrow. We have certificates for everyone and some things you won't want to miss tomorrow. So please come on time. And we are also going to be able to handle your payments for your transport and for your facilitation. With that, it's a goodbye from us for today, and enjoy the rest of your night. Thank you. Please come and get your dinner. Give me like 5 minutes.